May please, Your Lordship, in connection with item number 8 of today's list, Lordship, we have filed an additional affidavit. Person may allow me to bring up your record, Lordship.
You want to call the affidavit?
Yes, sir.
Item 8.
Affidavit.
All right.
May I please, Your Lordship? Also, I pray for listing of a motion matter tomorrow, Lordship.
Approach the registry. All right. This is a motion week.
Obla.
May I please, Your Lordship? I beg to mention for listing of two pending after vacation, my lord. Pending read petition. my lord.
When was it last listed?
Last admission stage, my lord.
When was it last listed?
In the month of January, my lord.
January. We'll get a date.
May I please, Your Lordship? Lordship, I pray for listing a WBC Lordship. This is an urgent matter, Lordship.
Motion.
Motion.
You go to the registry. Like I said, any motion matter, please approach the registry.
May it please,
Hmm.
Lordship. Lordship, I beg to mention for listing on contempt matter, it is of 2022, my lord.
Hmm.
Till
After
date-
vacation?
Till date has not been
After
complied.
vacation, if you want.
And 16 or 18, my lord, after vacation.
No, any? Okay, 18.
I'm
May I please, Your
Yes.
Lordship, offer listing two read petitions for tomorrow if possible.
What? For what?
Motion.
For motion, not possible.
We
They approach the registry.
We approach to the registry, but they have given time only after vacation. But it's a urgent matter, so
What to do? You approach again. Do you have the vacation bench also on 10th and 20th? All right. Please call.
List item 1 for motion.
Yes.
Please, Your Lordship, my lord, this matter relates to compassionate appointment, my lord. Here, the petitioner's father died on 11/2/2012.
Hmm.
He applied after attaining majority on 10/7/2014.
When?
On 10/7/2014.
Okay.
So thereafter, his case was not placed, and so he approached this honorable court, and the honorable court has passed an order. It is at page 29, my lord. There's a direction to place the case of the petitioner before the DLC. Accordingly, his case was placed, my lord, before the DLC, and the DLC recommended, my lord. DLC recommendation is in the additional affidavit, page 65. Serial number 11, my lord.
Which DLC is this?
DLC is, my lord, 30/11/2015,
DLC Karimganj.
Karimganj, my lord.
Serial number?
Serial number, my lord, 11. No, my lord, not 11,
What is the name?
not 11, my lord. His name is Sagar Chanda, my lord. Serial number
14.
14, my lord. Yes, my lord.
What is the recommendation?
So, while the DLC has decided to recommend the applicant for the appointment on compassionate ground, and it reveals from report of DEO that there is no vacancy available for appointment on compassionate ground. And on the last occasion, my lord, instruction was sought whether regarding the status, regarding the whether what information received in respect of the vacancy. But here, my lord, in case of a compassionate appointment, vacancy may then if it is not available in the department, present department, in any, he may be appointed in any other departments, my lord.
Then?
So, my lord, my humble prayer is that his case may be placed for before the SLC, because the DLC has already recommended, my lord. And since it is pending before the department, my lord, it is covered by the judgment, my lord, order dated 4/6/2025 in WPC number 2888 of 2025, my lord. This is the judgment, my lord.
The DLC did not send it to the SLC.
My lord, it is recommended, but your
Was it sent?
On the last occasion, my lord, instruction was sought regarding the vacancy position, my lord.
Hmm.
Your lordship may kindly see the last, my lord, lines, my lord. For the
Last what?
last lines in respect of the petitioner, my lord.
What are you saying? Last what?
Your lordship may kindly see the no vacancy available as per the prescribed quota.
I've seen it. I've seen it. I'm asking you
Yes,
whether
ma'am.
it was sent to the SLC or not. Not sent.
Sent, my
Not
lord.
sent.
Not sent.
Why it was not sent?
It because of the official, office memorandum, impugned office memorandum dated 18/9/2024.
Where's the OM?
Because of that, I have annexed it, my lord.
Page.
Annexed it at page.
OM dated?
Annexure E, page 43-44, my lord.
OM dated this 18th September.
Yes, my lord. 18th September, my lord.
Hmm.
So, my lord, thereafter, a series of writ petitions were filed by
Hmm.
similarly situated persons, my lord. And that order also I have annexed, my lord.
Yes. During. We have disposed of similar cases yesterday. Can it be disposed of?
Lordship, here, to my understanding, your lordship, directions will be to the DLC only to invoke that clause 15 as per clause 15, since the vacancy is not there in the concerned department. So, they may invoke any other department, that's all.
That is the recommendation also.
Because they recommend.
It will go to SLC, my lord.
I have confused.
You see page
Yes.
66? You have the writ petition with you.
Yes. please.
66, the remarks column, there is also say that since there is no vacancy, it may be recommended against any other vacancy in any other administrative department. In terms of paragraph 15 or what? 13
Yes.
or 15?
Yes, my lord. Office memorandum 15, my lord.
Paragraph 15 or 13?
Wait.
Page 66?
Page, my lord. Not, my lord, page 65, my lord.
65.
Serial number 14.
65 is the beginning. I'm talking about 66. DLC decided to recommend the applicant for appointment against admissible vacancy in any grade 4 post of
Yes.
any other administrative department.
Yes,
As
my
per
lord.
paragraph number, what is this, 15 or 13?
It will be 15.
15? You sure?
15.
Yes,
Yes,
ma'am.
I'm sure.
So we'll dispose it of accordingly. But Miss Chaudhary,
SP Chaudhary.
SB Chaudhary, learned counsel for the petitioner, and Mr. B. Diori, learned government advocate for the respondent numbers. One, two, three, and 6.
Yes.
Anyone for elementary? And Mr. P.K. Bora, learned standing counsel, elementary education department for respondent numbers 4 and 5. Stop having regard to the grievance projected by the petitioner. The writ petition is taken up for disposal at this stage. To stop next para. It is the case of the petitioner that since he was not recommended for compassionate appointment by the not recommended, since he was not considered for compassionate appointment by the DLC, Karimganj, is it?
Yes, ma'am.
He approached this court by filing WPC number 5298 of 2023. The writ petition was disposed of by order dated 22/9/2023 by directing the respondent authorities concerned to place the case of the applicant before the DLC Karimganj. Pursuant thereto, the DLC which held its meeting on 30/11/2023, considered the case of the petitioner, but could not recommend his name due to want of vacancy. So, however, the DLC at the same time decided to recommend consideration of the petitioner's case for appointment against any admissible vacancy in the grade 4 post of any other administrative department in line with paragraph number 15 of the office memorandum dated 1/6/2015. So despite the same, since the petitioner's case has not been considered by the state level committee bracket SLC, the petition is before this court. At this stage, next para, it is brought to the notice of this court that the state government, in the meantime, had come up with office memorandum dated 18/9/2024, by which appointment of compassionate appointment has been stopped in view of the introduction of compassionate family pension scheme. To stop. Aggrieved with the same, a number of writ petitions were filed before this court, and the lead case being 342 of 2025. All the writ petitions were disposed of by common order dated 3/4/2025, with the direction that all the pending applications be considered by the DLC or SLC in terms of the prevailing guidelines of the state government. Next, the learned counsel for the petitioner submits that since the DLC Karimganj had recommended the name of the petitioner for consideration against any admissible grade 4 post under any administrative department, in its meeting held on 30/11/2023. The case of the petitioner is also squarely covered by the said decision. The learned counsel therefore submits that case of the petitioner be placed before the SLC for consideration as per the recommendation made.
One line for your lordship, that page 66, your lordship.
Yes.
Page 66. Since it is stated that the DEO Karimganj has been requested to take immediate steps as per the decision of the DLC. So what it infers is that the DEO will coordinate the concerned departments and will take the stock of the vacancy and will inform to the DEO. So let one line be added that DEO will do the needful on his part, because
Okay.
DLC's decision was that.
Next, but at this stage, Mr. B. Diori, learned government advocate, submits that the DLC, while recommending the name of the petitioner, had also asked the district education elementary officer, is it? Sorry, district elementary education officer,
Sir, Sri Govind.
Karimganj, to take necessary steps in terms of the decision of the DLC. And therefore, he submits that An observation to that effect may be made by this court. Next para, considering the submissions made and upon perusal of the materials available on record, the writ petition is disposed of with a direction to the Secretary to the Government of Assam, Department of School Education, record respondent number 4, to place the name of the petitioner before the next SLC meeting. To stop in order to enable the SLC take appropriate decision in the matter. But he's not a party here, what to do? He's not a party. The Director of Elementary Education, bracket respondent number 5, shall instruct the District Elementary Education Officer, Karimganj, to take necessary actions for identifying the vacancy position in other administrative department to accommodate the petitioner, as was decided by the DLC.
30/11/15.
In its meeting held on 30/11/2023. All right.
Item 2,
Made is all okay. Followed I think this matter is also similar to earlier item number 1. This honorable court directed to consider that claim of petition of compassionate appointment.
Who is the first round?
First round, my lord, the page
26.
26, my lord,
26.
26. Lord. And due to my lord, page 29, my lord, this impugn office memorandum, my lord, is before your lordship. And similar, my lord, order, my lord, leave was granted.
No, DLC has considered your case?
No, my lord,
Not considered.
not considered. It was directed, my lord, in the year 2022.
So it's not a similar case then.
My lord.
You said it's a similar case. It's not a similar case. You are yet to be considered by the DLC.
DLC one.
Lordship, may kindly turn to page number 27. Honorable Court Order, Lordship.
Yeah.
On the basis of which he is pleading for recommendation, Lordship.
Mm.
Paragraph 3. Accordingly, the petitioner is directed to submit his next of kin certificate in the prescribed format before the concerned authority within a period of 2 weeks with the effect from today. But that means, Lordship, from 6 to 23. But there is not a single line regarding this, Lordship, when whether he has submitted the next of kin or not.
Mm. Yes.
Only thing is that, my lord, now, my lord, in view of this office memorandum, my lord, and latest, my lord, judgment passed by this honorable court, my lord, this honorable court may be pleased to, my lord, give, my lord, leave to the,
Oh, see, next of kin certificate, whether you submit or not, you tell me that.
well, it is submitted, my lord.
When? Where? How?
After, my lord, this order, my lord, when it was.
Where? Where's the statement?
The only thing, my lord,
Only thing means you have not submitted.
submitted, my lord, definitely.
Court's direction was February 2023.
Yes.
Correct. The office memorandum of the government stopping the compassionate appointment came after 1 year, more than 1 year.
My lord.
18 September 2024. In between, what did you do?
My lord, it is.
In between, what did you do?
It is pending before the DLC, my lord, because of to consider, my lord, in the meantime, my lord, this circular came by.
How it's pending before the DLC? So, see, you were asked to take certain steps
Yes,
to submit next of kin certificate.
yes, my lord.
Where is your statement to the effect that in terms of the order, I have complied with everything and despite that, they have not done it? Simply saying that similar case will not do. No, we are.
Yes, my lord. Yes, per my lord, this order may be considered, my lord, earlier order. My lord. Only
No,
thing
no.
is. Only thing is that, my lord, they are leaving.
Simply, we cannot say that like that. You see, duties cast upon you. You have certain duty to
Definitely,
perform.
If it is not fulfilled, my lord, it is not considered, but only thing is.
You file an additional affidavit
My lord.
indicating you have given next of kin of certificate. On which date, how you given, to whom you have given. As paid for by Mr. A.M. Borbuya, learned counsel for the petitioner, matter stands adjourned for 2 weeks. To enable him to file an additional affidavit indicating as to whether the petitioner had filed the next of kin certificate in terms of the order dated 6/2/2023, passed in WPC number 4439 of 2022, which was the first writ petition filed by the writ petitioner. Next.
Item 3.
Here instruction was sought for. Because in earlier occasion, my lord, in terms of this honorable court's judgment and order, my lord, the selection committee has complied with, and my case has been recommended by the governing body, my lord. And that has not been considered.
Lordship, instruction awaited, Lordship. The notice has not been issued, Lordship. Lordship may be issued and after action will place the instruction, Lordship.
Where's Mr. S. Das? He's your colleague.
Yes, yes, yes.
So why was it not submitted on the last court date? That notice may be issued so that I can get instructions. Nothing was said. Court said that get instructions. Recommendation is there. Why you're not appointing him?
I cannot say what happened.
You cannot say. You have not sought for instructions.
Lordship, after
You have not done your homework.
No, no, Lordship.
Huh?
And that day present, as Das is present, what happened, I cannot say, Lordship.
Then
And then, as an instruction, Lordship, notice may be issued, Lordship, after vacation, we file our instruction with affidavit, Lordship. That will be better, Lordship.
Mr. Chetri will issue notice then. What to do? We'll post it after the vacation. Mr. Chetri, learned counsel for the petition, is present. While Mr.
S. Bhuya.
S. Bhuya, learned standing counsel,
Higher
Higher
Education.
Education,
For 1 and 2.
appears for respondent numbers 1 and 2 and submits that he is still yet to receive instructions. In terms of the last court's order dated 30/5/2025. We'll stop. Next para, issue notice of motion returnable by 3 weeks. Mr. S. Bhuya, learned standing counsel, Higher Education, accepts notice on behalf of respondent numbers 2 and 3.
No, 1 and 2.
1 and 2. Who else is there?
Others, my lord.
Inspector of schools, you're not there.
Yes.
You cannot appear.
Yes. It will over. The government
Inspector of schools,
government officer.
Okay.
1, 2 and 3, okay?
Yes.
4, 5 is.
Petitioner to serve requisite copies of the writ petition to Ms. Bhuya, within 2 days. Stop. Petitioner shall take steps for service of notice upon respondent numbers 4 and 5 by registered post with AD due within 3 working days. List the matter again on so and so. Learned standing counsel, Higher Education shall obtain instructions by them.
Replay.
Item 4.
May it please the Lord. Matter relates to completion and appointment, Lordship. Petitioner approves earlier, Lordship.
Page number?
Page 11, page 22, start from 20, Lordship.
What was the direction?
Lordship, para 4, Lordship. Page 22, para 4.
What was the direction?
Accordingly, the rejection of the claim of the petitioner by the DLC of Lakhimpur district on so and so is interfered with, and the matter is remanded back to be placed before the next available meeting of DLC of Lakhimpur district for a fresh consideration to the application of the petitioner on merit.
Okay, then
Thereafter, Lordship, DLC recommended Lordship.
page number.
Page 33, Lordship, start 32, relevant 33, Lordship, serial number 11.
Just a minute. DLC of Lakhimpur,
Yes, Lordship.
serial number 11.
Yes. Placed as per-
Durlov Bora.
Yes, Lordship.
It sounds like a Russian name, huh? Hmm? Durlov.
Durlabh Bora.
Then, what is the recommendation? Please read the
Yes, sir.
remarks.
Remarks column. Placed as per Gov letter number so and so dated 2/6/2023 received from the Deputy Secretary to the Gov of Assam Department of School Education and decided to recommend for LP teacher under the office of the District Elementary Education Officer Lakhimpur.
Okay, then
Thereafter, Lordship, matter is pending before the SLC for consideration.
was it forwarded?
Yes, Lordship.
When? When was it forwarded?
Lordship, recommendation letter is not available in my hand, Lordship.
Not recommendation letter, forwarding to the DLC.
Forwarding letter, Lordship. Sorry. Forwarding letter.
Then how do you say that it's pending before SLC? Maybe it never reached the SLC also.
Lordship, it is pending before SLC, Lordship.
How?
Lordship, recommendation was made on 7/7/2023, Lordship.
DLC is sitting here recommending,
Yes.
but SLC is sitting in the next room. How will it reach there? Somebody has to send it.
Yes, Lordship.
Anybody has sent it?
Send it, Lordship.
When?
Date is
Yes, madam.
Yes, Lordship, it was recommended, but not placed before the SLC yet, Lordship.
Let it be placed then.
There is no time, Lordship.
Sorry?
At the next SLC, Lordship, that will be placed before.
Let it be taken up then. We'll dispose it of again with similar order. Your good name?
N. Hussain.
Heard Mr. N. Hussain, learned counsel for the petitioner. And Miss
Esquire, Lordship.
Esquire, learned standing counsel
No, Lordship, government advocate.
or learned government advocate,
1, 2,
appearing
3,
for
1, 2, 3, and 6.
respondent numbers 1, 2, 3, and 6. Then M. Fukan, is it? N. Fukan. You are for elementary. Also had Miss N. Fukan, learned standing counsel, elementary education department, for respondent numbers 4 and 5. So having regard to the nature of grievance projected by the petitioner, the writ petition is taken up for disposal at this stage. We'll stop next para. This is the second time the petition is before this court. We'll stop. The earlier writ petition being WPC number 1766 of 2022 was disposed of via order dated 14/3/2022 by interfering with the decision of the DLC Lakhimpur not to recommend the petitioner's case for compassionate appointment. And accordingly direct the DLC concerned to reconsider the case of the petitioner. To stop the DLC Lakhimpur thereafter met on 7/7/2023 and the petitioner's name was recommended for appointment on compassionate basis as LP teacher under the office of the District Elementary Education Officer, Lakhimpur. And his name was placed at serial number 11 of the meeting minutes. Full stop. The learned counsel for the petitioner submits that despite the recommendation, since the petitioner's case has not been considered by the state level committee, bracket SLC till date, comma, the petition is before this court. Next para. It is further seen that the state government in the meantime had come up with office memorandum dated 18/9/2024, by which appointment on compassionate basis was stopped in view of the introduction of the compassionate family pension scheme. Stop. However, it may be seen that the case of the petitioner has been recommended by the DLC on 7/7/2023. And that this court in WPC number 2429 of 2025, relying upon the earlier judgment rendered by this court, earlier common judgment is right, rendered by this court in WPC number 342 of 2025, wherein the office memorandum dated 18/9/2024 was put to challenge and directed that all pending cases for compassionate appointment be considered by the DLC/SLC as per the guidelines made by the state government. Full stop. It is found that the present writ petition is also covered by the said decision. Stop. Accordingly, the writ petition is disposed of by directing the secretary to the government of Assam, School Education Department, bracket respondent number 4, to place the matter before the next SLC meeting for considering the petitioner's appointment on compassionate basis in terms of the recommendation made by the DLC on 7/7/2023. Yes.
Item 5.
May please, your lordship.
Hmm.
This is also same lordship, similar on it, petitioner recommended for grade 4 post. Same district, same DLC lordship. Petitioner approached earlier. Page 20 start from page 20
Item 5 also.
lordship.
6 also.
No,
5.
6 is different. Yes. Petition. Page 33 serial number 6 lordship. Petitioner name appeared.
Just a minute. The writ petition earlier was
290.
okay. Can you manage?
Three.
Parties' name are same. I mean, the council's names are same. Then the writ petition, earlier writ petition is WPC number 4517 of 2022. And date of disposal is order dated 2/2/2023. And DLC minutes is same. And petitioner's name is at serial number?
6 lordship. Page 33.
Serial number 6.
6. Page 33. Grade 4.
And recommended against the grade 4 post under the office of the Inspector of Schools. What is LDC?
LDC Lakhimpur District Circle lordship.
Lower division.
Lakhimpur. No, Lakhimpur District Circle.
Okay.
Lakhimpur lordship.
Lakhimpur District Circle, Lakhimpur.
Lakhimpur lordship. LDC.
Okay. I think the rest is similar, isn't it?
Same district.
Okay.
For 4 and 5, yeah. For secondary, it's a secondary method.
Oh,
Earlier one is elementary method, of this 4 and 5.
parties are not same then. Miss S. Goar appears for respondent number
1, 2, 3, and 6, Lordship.
1, 2, 3, and 6, and Mr. SMT Chisti appears for respondent number 4 and 5. That is the only.
Obliged, Lordship.
Item 6.
What pertains to lots of completion and appointment losses, second round of litigation, page 23. Page 23, second round of litigation losses. 24, order dated 6/10/2023. From paragraph 3 onward.
What was the direction?
Direction was to the DO to place before the
DLC.
DLC against any available vacancy letter. And any other administrative department. Page 24.
This is under clause 15.
Clause 15. So accordingly, Lordship, in compliance of this order, matter was placed before DLC. And DLC recommended the name of the petitioner for
Page number?
page number 36. It starts from page 34. Relevant portion for my in case of petitioner is page 36, CL number 12. They recommended for assistant teacher in LP school.
DLC is 19/9
Dated is
19/9/23. DLC Hailakandi.
yes, 19/9/2023. Recommendation page
Serial number
CL number 12. Bottom Lordship.
12 and page number.
Rahila Parvin Chaudhary.
Okay,
Page 36.
36.
Recommended for assistant teacher in LP school.
I see.
Clause number 4. Name of post, assistant teacher for LP. Now in view of 3/4/2025 order, Lordship is covered.
Yes, who will be appearing? Respondents?
Elementary department. Is it there? Elementary. Sorry.
This is a similar case.
Yes, yes.
Heard Mr. A. Deka, learned counsel for the petitioner. Mr. B. Diori, learned government advocate for responding numbers 1, 2,
3
3,
and 6.
and 6.
4 and 5.
And Mr. SMT Chisti, learned standing counsel, elementary education department for responding numbers 4 and 5. Stop. Having regard to the nature of grievance projected by the petitioner, the writ petition is taken up for disposal at this stage. Stop. Next paragraph. This is the second time the petition is before this court. The first writ petition being WPC number 5865 of 2023 was disposed of by order dated 6/10/2023 by directing the district level committee (DLC) Hailakandi to consider the case of the petitioner for compassionate appointment in terms of clause 15 of the office memorandum dated 1/6/2015. Stop. The said clause pertains to the benefit of consideration in any other administrative department in case there are no vacancy in the parent department. Stop. Pursuant thereto, the case of the petitioner was considered by the DLC Hailakandi, which held its meeting on 19/9/2023. And the petition's name appeared at serial number 12 of the said recommendation, wherein he was recommended for appointment as assistant teacher in LP school. Despite the recommendation, since no consideration has been done by the state level committee (SLC), the petition is before this court. So. Next para, it is submitted at the bar that in the meantime, the state government had come up with an office memorandum dated. Where's the OM?
Page 18.
Sorry? Stopping the compassion appointment?
Page 39. Yes, okay.
OM dated 18/9/2024, by which all compassionate appointments had been stopped in view of the introduction of the compassionate family pension scheme. To stop, aggrieved with the office memorandum, a large number of writ petitions had been filed, and the writ petitions were disposed of by a common order dated
3-4. 3-4-2. 3-4, no, sir.
3/4 what?
3/4/2025.
3/4/2025.
The leading case is 342.
And the lead case being WPC number
342 of 2025.
342 of 2025.
And batch of writ petition.
To stop, this court directed that all the pending cases for compassionate appointments be considered in terms of the pending guidelines of the state government. Without relying upon the office memorandum dated 18/9/2024. To stop, since the petitioner's case was considered by the DLC on 19/9/2023 and duly recommended, it only appears that the case of the petitioner is also duly covered by the said direction. Stop, in view of above, the writ petition is disposed of to the direction to the secretary to the government of Assam.
As well as 6 also, because 6 is the chairman of the DLC. His duty is to forward the application. But I'm reliable, so I came to know they forward, but I could
School
not
Education
complete the
Department, bracket
Correspondent
respondent number 4, respondent number 3. And the
6 also.
District Commissioner come Chairman of DLC Hailakandi, bracket respondent number 6, to place the name of the petitioner before the next meeting of the SLC for
DLC পাৰ কৰিছে বুলি এতিয়া ইয়াতে submit কৰি আকৌ দিয়ে।
considering
Forward কৰিম। যদি forward কাম কৰি দিওঁ।
the case of the petitioner for compassionate appointment in terms of the recommendation made by the DLC Hailakandi on 19/9/2023. Why? What's wrong, Mr. Deori? You look very unhappy.
Seven,
Right.
Yes.
Petitioner to the lordship for compassionate appointment in post lordship.
What is this case?
Compensation.
Compassionate.
Appointment lordship. For grade 4. This is the second time litigation lordship.
Okay, where is the first litigation? Have I annexed the order?
Yes, Lord.
Page number?
Page number 21. Lordship.
21. Yes, then?
After this order, Lordship, the several occasional meetings held, Lordship.
No, after this order means what? What was the order?
The Lordship, relevant portion, Lordship. Like, para 3, Lordship. On the above issues highlighted.
Now, para 5, from the above narration, it is clear enough that the petitioner's case was never considered on merit by the and on the ground that her income was not found. However, since the income certificate is found available, the reconsideration of the application by the DLC Nagaon is ordered.
Then
reconsideration.
reconsideration.
Petitioner's claim for get considered on merit with due regard to the income by the side. So accordingly, this was on dated 21/7/17.
So there was certain criteria for giving that income certificate
Yes, yes.
for consideration.
Yes, yes. Now.
Have you given that certificate?
Yes, Lord.
Okay. Then did the DLC consider your case?
No, Lordship. Page 36, Lordship. Relevant person. Vernacular is 36A. In serial number 12, Lordship.
36.
36A,
Serial number 12.
Lordship.
Yes. Read.
The case of the Anwar Khat Begum is examined. Her proposal was placed before the earlier DLC meeting held on so and so, but not recommended due to want of vacancy as per Honorable Court's order dated so and so. The proposal was placed before the DLC meeting dated so and so for grade 4 post, but not recommended as there was no vacancy against 5% cadre strength to appoint on promotionate grounds in grade 4 post, as well as the period of 2 years from the date of making application is already over. Our proposal was again placed in the DLC meeting held on so and so, but not recommended as it was already disposed in the earlier DLC meeting. Now her proposal cannot be recommended on the same ground, Lordship. But there is similar serial person or appointed, Lordship. Every time Lordship rejected on the ground of a lack of vacancy, Lordship.
So if there's no vacancy, what to do?
But Lordship, similar person are appointed, Lordship.
Without vacancy.
There is some vacancy, Lordship.
Where is the vacancy?
Lordship, some person is appointed in page number, Lordship 30. 30, Lordship. 30. 13 to 20, Lordship.
What is page 30? Corrigendum.
Is 30.
Why you're looking surprised with your drafting? You have not drafted this writ petition.
Yes, Lordship.
Who has drafted it?
My senior, Lordship.
Your senior. So all of us are searching for your, what do you call, relief. Relief what can be given to you. You're taking the time of the court. Second round, writ petition, then as per court's direction, you were considered many times, not once, 3-4 times. They say there's no vacancy.
Lordship, in case
Then what will happen?
30A, Lordship. Therefore,
So what is 30A? It's only a corrigendum.
some person are appointed in.
How appointed? Why appointed? Tell me. Simply showing me corrigendum will not do. It's neither here nor there. Which is the DLC which considered you? DLC of which district?
Nagaon, Lordship.
Nagaon. Is there any case?
Lordship, some person in 2024 was appointed, Lordship. If there is no vacancy, how can they appoint the other person, Lordship?
Some person were appointed in 2024,
24, Lordship.
Okay. But your case is of 2017. The writ petition was 2016. Disposed in 2017. Who expired?
Husband, Lordship.
Husband, when? in 2016, 17 for 2016. So at the relevant time, there was no vacancy. 2016, 17, 18, 19, 21. 5 times you have been considered. There was no vacancy. Hmm.
Lordship, there is a High Court order after 13 years lordship. The petitioner is considered for
Who has been considered?
some similar situated person lordship is before your lordship. Then the order or this order lordship allow him to reconsider in page number lordship 37. There are 3 lordship. 38, there are 3. After 30 years lordship, 13 years.
So what benefit you'll get? Your case also was directed to be placed before the DLC. This, in spite of your shortcomings, not having the income certificate. You produce the income certificate in the High Court, then court said, okay, now you go and let DLC consider you. So not once, twice, for 5 times you have been considered. They say there's no vacancy.
That there is no vacancy. If there is no vacancy lordship, how can they appoint some other person?
In 2024.
Yes, lordship.
Why not? Vacancy happened later on. When there was no vacancy during your time, there's no vacancy. That's what it says. What else can you submit?
I kindly pass over the time. My senior will be
After vacation, you prepare properly.
Lordship. Yes, lordship.
You prepare properly. There's an office memorandum also, which you may like to read, clause 15. List again after the summer vacation,
I love this.
as paid for by the council for the petition.
Item 8.
Yes, what is the affidavit? Who called in this?
The affidavit lordship matter relates to suspension of the petitioner lordship.
So what affidavit you have filed? Who directed you to file affidavit?
Lordship,
It's coming for the first time.
my first time lordship during the
Then on what basis you file this affidavit?
after filing of the instant petition lordship,
Uh,
they fix a date for hearing of the suspension lordship
okay.
on the 2025 lordship yesterday
Okay.
only. And a copy was communicated to the petitioner lordship. Accordingly, we wanted to bring it on record lordship. That's why we filed that.
So that you have to take permission. Even before the case is listed for motion, you're filing affidavit. And if this goes on, I think before matter comes for motion, everybody will start filing affidavit. This is regarding what? Suspension? Prolonged suspension.
Yes, lordship.
Where's the order?
Lordship. Page 33 lordship, and it's at 6.
Hmm. Your suspension is due to arrest.
Yes,
Or what?
lordship. Charges of corruption lordship.
And suspension from which date?
Suspension date is from lordship,
Date of arrest.
date of arrest 10/7/2024.
What is the date?
10/7/2024.
With effect from date of arrest by so and so. And this order is of 38/2024. Then what is your case?
Yeah, I was arrested in connection with a
No, that's okay. That criminal case will go on. But they've suspended you. Now, why have you come before this court?
for reinstatement lordship.
Reinstatement. On what basis?
The prolonged suspension lordship, no hearing is and no memorandum of charges were framed against the petitioner.
And your additional affidavit is regarding
Regarding
charge.
last date of hearing lordship
Last date of hearing. Hearing for what?
for suspension of miscellaneous proceeding.
Yes, Shokos was issued, my lord. He has filed his reply. my lord.
What is the law regarding suspension?
As per Ajoy Chaudhary, my lord.
Ajay Chaudhary says what? 3 months.
3 months.
Every 3 months it has to be reviewed.
Review is required. Well,
Has
here-
it been reviewed?
Well, I have to take instruction regarding review, my lord.
Not yet, sir.
Not reviewed. You are still under suspension.
Yes, sir.
Well, I may be allowed to take instruction, my lord, immediately after vacation, my lord. There may be review, my lord.
Heard Mr.
MK Bora.
M.K. Bora, learned counsel for the petitioner, who submits that grievance of the petitioner is that he has been kept under prolonged suspension without any review. To stop, the learned counsel submits that the petitioner was placed under suspension with effect from 10/7/2024 by order dated 30/8/2024, and he remains to be under suspension even as on date. To stop, he submits that although hearing was conducted on
25. 25/6, Lord.
2025. But petitioner continues to remain under suspension till date. Will issue notice in view of above, issue notice of motion returnable by 3 weeks. Mr.
PK Bora, my lord.
P.K. Bora, Learned Standing Counsel, Elementary Education.
For all the rest.
Department accepts notice on behalf of all the respondents. Stop, as such notice is complete. Petitioner to serve requisite copies of the writ petition to the Learned Standing Counsel within the course of the day. Possible today? List the matter again on so and so.
357.
Learned Standing Counsel to obtain instructions as to whether any review has been conducted on the suspension imposed upon the petitioner. Bless, please.
Item 9.
May it please your lordship. My lord, this matter relates to compassionate appointment, my lord. Here, my lord, the petitioner's father died on,
Second time.
no, my
First
lord,
time.
first time. Died on
Okay, died on
13/2/2008.
13 to 2008. Okay,
Died on 11/3/2007.
okay, 11/3/2007.
She applied on 13/2/2008.
Okay,
Thereafter, her case was, there were official communications in the department, my lord, that nothing was done, my lords. So the petitioner constantly visited the office. I have explained it, para 3, my lord. So the respondents again asked her to submit another application. So she submitted another application on 14/7/2023.
was such a long gap.
Yes, my lord. Subsequently, they considered this application and there was an official communication, page 34, my lord. There, my lord, your lordship may kindly see, I am reading the relevant portion with reference to a subject so and so. I am to inform you that matter relating to compassionate appointment due to death of so and so could not be considered for placing DLC under this district due to the following reasons. The current application is treated as delay in submission after a gap of more than 16 years. No evidence of timely submission of application is found recorded in the record of DLC. You are therefore requested to communicate the concerned authority where you actually submitted your application and status thereto as on date may please be intimated to the undersigned within 7 days. Accordingly, she again submitted all her documents within 7 days, page 35, my lord. In fact, my lord, the first application was duly received by the authorities. Your lordship may kindly turn to page, my lord, 27, my lord.
See, you submitted again on 4/8.
Yes, my lord. Fresh, my lord. But thereafter, my lord, it remained pending, my lord.
3 times you have submitted.
Yes, my lord.
13/2008, then 14/7/2023, then on 4/8/2023.
And your lordship may kindly see all the communications, my lord. That is at page 31, my lord. This was received by the block and the block again forwarded to the district elementary education officer. So all these documents she again submitted with me in the office, my lord. So her case may be considered, and if my lord, she is eligible, her case may be placed before the DLC, my lord.
But why is the delay so much?
Delay, my lord, I have explained it para 3, my lord. At page 9. Earlier, she was asked to wait, my lord, for some days, my lord. She waited and she constantly visited the office. Then only they told her to ask her to submit another application so that they can consider. But now they are saying that her earlier application is not there in the record, my lord. So she again submitted, my lord. And the first application also I have annexed in my writ petition, my lord. It bears their seal and signature, everything, my lord. Annexure C1, C2.
So Annexure F is a communication to you, isn't it?
Yes, my lord.
So you are therefore asked to communicate the concerned authority whether you actually submitted your earlier application, if made, and the status.
Again submitted all her documents, my lord, including the earlier first application, my lord.
Why is that?
My lord, that is, I have already annexed here, my lord, your lordship.
Page first application. 13.2.
First application, yes, my lord.
13.2.
Page, my lord, first application C1, page 27, my lord. First one. Your lordship may kindly see at the top left side, my lord, it is duly received. Page 27.
This is not in the format also.
Then format is the next page, my lord.
Format,
Page 28.
Format is,
Page 28, 29.
what is the date?
Date, my lord, date is there, my lord.
Where?
At page 29, 13/2/2008. It was duly received by the block elementary education officer. The signature and seal is there at the bottom left side, my lord, page 29, my lord.
13/2/2008.
Yes, my lord. Then subsequently on the same day, your lordship may kindly see the block elementary education officer again forwarded it, page 31, my lord. This also contains signature and seal. For page 31, the block elementary education officer forwarded to the district elementary education officer for necessary action, my lord.
He wrote it by hand.
My lord, this was written by the block elementary education officer.
By hand.
Yes, my lord.
There's no what? No typewriter in the office, government office.
Sometimes, my lord,
How many application he'll write? DDO, DEO. Mr. Diori, what is this?
Lordship, here, otherwise the matter is bear by laches and delay, otherwise. But since the petitioner has preferred the application in the year 2008, so there it may so happen that the matter has been placed. So let them go through the older records. And in the meantime, if we bring Tiwari, it stands at it stands in between. But since it has been left for the state in the bunch of cases to whether the state will do or not in that bunch of cases, your lordship. So let it be remanded back, and if it has been placed, let the petitioner be informed. And but if the same has not been placed, let them matter of delay is there, but let them her matter be considered once, and they may reject it on. They may act as per the OM.
otherwise they are processing, my lord.
They are processing it.
Yes, my lord, because the last, the official communication says, my lord, whereby she was asked to submit
Just to
all her
maintain the
documents.
parity and-
Page 34, my lord.
Page 34.
Page 34, my lord.
Where's 34?
Annexure F.
Oh, yes, okay. 34.
The last para, you are therefore asked to communicate the concerned authority so and so where you actually submitted an application and status thereto as on date, and please intimate the undersigned within 7 days from the date of receipt of the letter. So immediately she submitted all her documents.
So that's the end of the story.
No, my lord, they have not responded now.
That's why.
Let the
That is
authority
the-
also visit the records from 2008. Let the authority, your lordship, while doing so, carrying out the exercise. And if it has been placed, let her be informed. And if it is not placed, let her be given a chance.
Okay.
From the record itself here, my lord, it reveals that they is not placed, my lord, yet. Because they could not find her application, my lord.
Art Miss S.B. Chaudhary, learned counsel for the petitioner. Mr. B. Diori, learned government advocate for respondent numbers
For 1, 2, 7 and 8.
1, 2, 7, and 8. And Ms. S. Shutia, learned standing counsel, government education for respondent numbers 3, 4, 5, and 6. Stop having regard to the nature of grievance projected by the petitioner. The writ petition is taken up for disposal at this stage. Stop next para. It is the case of the petitioner that petitioner is a lady or a gent
Lady, my lord.
that who expired? Her father.
Father, my lord.
Her father died in harness on 11/3/2007, and following which she submitted an application for compassionate appointment on 13/2/2008 as per the prescribed format. Where was that format you showed me?
Format page 29, my lord. 28, 29.
Submitted to whom?
Before the block elementary education officer.
Block or district elementary education?
She submitted before the block and the block has forwarded it to the district elementary education officer. By lecture D, page 31.
Before the district elementary education officer, Kamru, through the block elementary education officer, Hajo. And the said application was received by the said authority on 13/2/2008. Stop. While the petitioner was waiting for her application to be considered by the district level committee concerned, since no steps was taken for a long time, the petitioner again filed an application for compassionate appointment on 14/7/2023. Where's the application?
And
14/7.
it's page 32, my lord. 32 and 33.
Before the district commissioner, Kamru. To stop in response to the same, the additional district commissioner on 1/8/2023 wrote back to the petitioner that there was delay in filing her application and that there was no evidence about the timely submission of the application for compassionate appointment in the record of the DLC. To stop, she was therefore asked to submit her earlier application and the status as on date within 7 days of receipt of the letter. Stop the petition accordingly submitted all the relevant documents before the District Commissioner Kamrup Amingaon on 4/8/2023. So, however, as no further steps have been taken, the petition is before this court. Next para, it is submitted at the bar that the state government White Office Memorandum dated 18/9/2024 has taken a decision to stop compassionate appointment in view of the introduction of the Compassionate Family Pension Scheme. Stop agreed with the office memorandum, a series of writ petitions were filed before this court. Stop consequently, the writ petitions were disposed of via the common order dated 3/4/2025, and the lead case being WPC number 342 of 2025. By directing the state respondents to consider all pending applications for compassionate appointment by the DLC/SLC in terms of the guidelines formulated by the government. Stop considering the fact that the petitioner had submitted her application as far back as on 13/2/2008, and thereafter on 14/7/2023. The writ petition is disposed of with a direction to the respondent authorities concerned to examine the case of the petitioner. And if it is found that the application for compassionate appointment was indeed submitted on 13/2/2008, the case of the petitioner be placed before the DLC concern, before the next DLC concern for consideration as per the relevant guidelines in this regard. Who will take necessary action?
Necessary action, whether
Mr. Dewey, who will take necessary action?
Lord,
District level or director or who?
district level, district level.
DEO.
No, just I'm submitting.
This respondent number 5 or 6?
Respondent number 7.
District Commissioner.
Yes.
To stop the this
Documents be forwarded by the concerned department. DEO. Apni kag dise?
DEO.
DEO.
I blocked.
That respondent number 5 will provide the necessary to respondent number 7. And respondent number 7 will act upon.
The petitioner shall, within 10 days from today, submit a certified copy of this order along with a copy of the writ petition to the respondent number 5, that is the District Elementary Education Officer, Kamrup, Amingaon, Guwahati, who shall examine the same. And if it is found that the petitioner had indeed submitted her application on 13/2/2008, her case for compassionate appointment be placed before the District Commissioner come chairman, district level committee, Kamrup Abingaon, bracket respondent number 7. Within a period of 4 weeks of making such verification with the above observation and direction with petitions as disposed of.
My one line be that just for my, that if it has been placed, might be informed to her. It
Okay.
may happen so because incumbent changes. So perusal-
Before parting with the records, it is further provided that it may so happen that the case of the petitioner might have already been considered at some point of time. So stop, if that be so, comma, the outcome of such consideration be informed to the petitioner.
Item 10.
Lordship, the petitioner has been agreed by the order dated. Lordship, may kindly come to page 31, Lordship.
Yes, what is this?
Case of interest in academic matters of the school and interest of the in charge of academic matters of the school. Lordship, on the retirement of the incumbent principal, Lordship, by Annexure 31, this one Ranjit Kumar Sharma, who is the respondent number 4, has been now. Lordship may come to the next page, page 30.
Ranjit Kumar is respondent number 4.
Respondent number 4. Lordship.
He has been placed as in charge.
In charge,
Academic
interest.
features.
Academic in charge.
Lordship. Other function has been performed by the inspector of schools, Lordship. Now, Lordship may come to the next page, page 32, the seniority list.
What is the name of the school?
Lordship.
Name of the school?
Pati Darang Vidyapit Higher Secondary.
Secondary school. Okay, next page.
Next page. Seniority list, Lordship. Number 1 is on Ratnakanta Bora.
You should have annexed it
Yes, Lordship.
horizontally.
Yes,
Yes,
Lordship.
Lordship, I have fine.
Now we have to
That's a
turn the
mistake.
file around like the paratha.
That's a mistake on our part, Lordship. That's a mistake on our part.
Yes.
This is Ramak.
Serial number?
Serial number 1, Ramakanta Bora, initially he was given, but he refused. Then I'm at serial number 2. And the
Number
person
2 is
who's been
petitioner.
given is serial number 3. I am the selected assistant headmaster of the school. So as per the schedule, Lordship, in seniority also I am placed above him. As per the schedule of the rule, I am placed at a higher pedestal than the assistant teacher. In spite of that, he has been given. Now, this Lordship may say this.
You have been shown as assistant headmaster.
I am assistant headmaster.
Then what is your grievance?
No, he has been given the in charge of the academic matters of the school. He was junior to me.
Academic.
Yes. Lordship say it's only a temporary arrangement, but I am relying on a decision, Lordship. Even
But you have the administrative control.
no.
He's into academics, you're into administrative control.
By the inspector of schools.
Oh, inspector of schools, okay. So what
He
is
was
to be done?
assistant headmaster, I think I think he was in the ME school also. It was amalgamated on the, because of amalgamation, he was
Lordship,
as an assistant headmaster.
Lordship may kindly come to paragraph 5, Lordship, 15, Lordship.
Yes.
May I read, Lordship?
Hmm.
It is true that holding of office of principal on in-charge basis is a temporary measure, but at the same time, it cannot be denied that though not a regular posting, holding of office of principal of a school is an important assignment and carries its own weight. Therefore, seniority cannot be overlooked. Even while making officiating arrangement or such other temporary arrangement, seniority cannot be ignored, as appointing a junior person as in-charge principal may have an adverse impact on the school administration and consequently on the academic environment of the school. In fact, the subsequent government decision itself takes makes it clear the position of clear by stating that it would be applicable selection of principal both in. Even I am a B.Ed and the person who has been given, he is also lacking qualification. He is not a B.Ed qualified.
Okay, what does it say?
He said that even in temporary arrangement, senior person cannot be ignored.
No, see, this out here we just read. The position is clear by stating that it would be applicable to selection of principal, both in charge basis as well as so and so.
Regular basis.
What will be relevant is the seniority.
Seniority, Lordship. Even in temporary arrangement, you cannot ignore the senior.
So this is since when?
Since
Uh,
22nd of May, he has already joined Lordship.
Your lordship can always stay, if prima facie, if I can establish my case.
Mr. Chisti, what do you say?
No, Lordship notice should go because we have to heard the respondent for.
So on the next date, we'll consider the
Yes,
interim. Part Mr. B. Chaudhary,
Chakrabarti.
B. Chakrabarti, learned counsel for the petitioner, who submits that the petitioner is aggrieved with the order dated 22/5/2025, bracket annexure I, by which respondent number 4, who is junior to the petitioner, has been allowed to look after the academic matters of the Pati Darang Vidyapit Higher Secondary School. Stop. The learned counsel submits that the administrative business of the school is under the
Charge of inspectors.
charge of the inspector of schools. Which inspector of schools?
KDC, they come to
Kamrup.
district circle.
KDC Kamrup Amingaon.
Yes.
Stop. The learned counsel submits that the action of the respondent authority concerned is clearly in violation of
Has been done ignoring the senior,
has been done.
ignoring the senior teacher.
Has been clearly in violation of the. No, you cancel that. The learned counsel submits that the action. The respondent authority concern has clearly ignored the seniority position of the petitioner, and therefore the impugn order should be interfered with by this court. In support of his submission, learned counsel has relied upon the case of Pradeep Chakravarti versus State of Assam and others, reported in
2012 5 GLT 656.
2012
12 5
5
GLT.
GLT
Page 656.
656. In view of above, next para, issue notice of motion returnable by 3 weeks. Mr. SMT Chisti, learned standing counsel.
1, 2, and 3.
Education Department accepts notice on behalf of respondent numbers
1, 2, and 3.
1, 2, and 3. 4 is the private respondent.
Yes.
No, school.
No,
Over.
private respondent.
Private respondent.
And 5, oh, okay. As such, formal notice is not required. Petitioner shall serve requisite copies of the writ petition to Mr. SMT Chisti within 2 days. To stop, petitioner shall take steps for service of notice upon the respondent number 4 by registered post with
As a
ready
Dusty.
as well as by Dusty through the registry of this court within 10 days. Stop, the petitioner shall thereafter file an affidavit as proof of service. Next para, also issue notice on the interim prayer made by the petitioner. Also returnable by 3 weeks. List the matter again on so and so.
Deeply obliged.
This was item number 10. There are 20 motion matters. No? Yes, come back in 5 minutes.
May it please your lordship. Your lordship, this matter is similar to WPC 3523 of 25, which was disposed of on Monday.
Your lordship, I have
23rd.
order copy, your lordship.
Okay.
Other matter is also your lordship similar.
12 and 13.
12 and 13.
I think similar order can be passed.
Yes, your lordship.
This is item number 11. 11, 12, and 13.
11, 12, and 13.
Only party's name and case number will differ, isn't it?
Yes, Your Lordship.
Okay, keep it here, right? Same order. Party's name and case number will differ, that's all. Miss M.K. Brown. She's M.K. Brown and Miss D. Das. P. Das was standing counsel, secondary education. Okay.
I'm deeply obliged.
14,
No one? None appears for the petitioner when the matter is called. This is again after the summer vacation.
15,
May it please your lordship.
Yes.
My lord, the impugned order is at page 36. I'll start from the impugned order, my lord, page 36.
Yes. What is this regarding?
Yes, my lord, this matter is regarding the grant of the post of grant of in charge of principal.
In charge principal.
In charge principal, my lord, at TC school, TC Government Girls High School, my lord, and MP school, MS. Page 36, my lord.
Yes.
If I'm permitted to read, my lord.
Yes.
The existing principal, namely Shri Chitaranjan Kolita of TC Government Girls High School and MP School, High Secondary School and MP School, Guwahati under Kamrup M District is retiring on 31/1/2023. Accordingly, the principal in charge of TC Government Girls High Secondary and MP School submitted a proposal along with seniority list of 12 teachers, including PGT and graduate teachers of the school, for allowing the next senior most eligible teacher to act as principal in charge of the school with effect from 1/2/2023. On verification of seniority list and other relevant documents, it is seen that only Srimati Subhalakshmi Borua, assistant teacher, obtained her B.Ed degree on deputation. The other teachers of the seniority list who are senior to her and have had B.Ed qualification could not produce necessary order permission of the appointing authority for pursuing B.Ed degree as per clause 13 of the Assam Civil Service Conduct Rules 1965. No government servants while in government service shall join or attend any educational institution for the purpose of preparing himself for or shall appear at an examination of a recognized board or university without obtaining the previous permission from the appointing authority. In view of the above and in the interest of the public service, Srimati Subhalakshmi Borua, assistant teacher, is hereby temporarily allowed to hold the charge of principal in charge of TC Government Girls High School, High Secondary and MP School, Guwahati, along with financial power to draw and disburse the salary of the staff of the said school under FR 49C until further order. Now, my lord will kindly see that this order was issued in the month of January 2023.
23.
2.5 years had passed. Now, thereafter, what had happened, my lord, was that the petitioner had preferred two representations. The representations, my lord, are at page 37, the typed English copy, my lord, and at page 39, which is a subsequent representation, both in the year 2023. Thereafter, my lord, Thereafter, my lord, there was a recent representation which was filed on 29/4/2025 at page 42. Page 42, my lord.
Yes.
This is the latest representation which I filed, my lord, before the authority, before the respondent number 2, 29/4/2025. My representation, my lord, was based upon various rulings and precedents rendered by this honorable court on the issue of prosecution of higher studies without obtaining the NOC. Thereafter, my lord, at page 45, Annexure K, I, along with the respondent number 5, rather, my lord, was directed to attend a hearing which was scheduled on the 4th of June 2025. We attended, my lord, but there was no closure to that hearing. Now, before I take your lordships to the rulings of this honorable court, I'll implore your lordship to kindly come to page 70.
17.
17, my lord, 17. It's a state-wise draft gradation list which was dated 4/3/2025.
Hmm.
The gradation list, my lord, starts at page 70.
Yes.
This gradation list, my lord, pertains to a list of seniority of postgraduate teachers. My name features under serial number 23. Serial number 23.
Petitioner.
Petitioner, my lord. Respondent number 5's name does not feature in this list because she is an assistant teacher, not a postgraduate teacher, but that is not the ground that I'm imploring now, my lord. Then your lordship will kindly come to page 28. Page 28. Page 28 is the annexure D, my lord, where my name, it's the seniority of the state seniority of graduate and postgraduate teachers. My name, my lord, features at serial number 68, and the respondent number 5's name features under serial number 80. The page is at page 31, the relevant page, my lord. The typed copy is at page 28. Your lordship has seen that.
Private respondent is respondent number 4.
5, my lord.
5.
5, my lord. Her name features at serial number 80. My name features under serial number 68.
Page number?
Page number 31 is the actual copy of the certified to be true copy of the gradation list. Page 28 is my typed copy.
Okay, the abstract 68 and 30.
68,
80.
80. My lord, my seniority over the private respondent is not disputed.
Okay.
In fact, I am the senior most teacher in the government school. Now, the ground which was taken by the authorities to deny the grant of
Permission not taken for
permission not taken, my lord. In this regard, my lord, I would like to place some judgments of this honorable court.
Yes.
Yes. And in my humble submission, my lord, these orders have attained finality, my lord.
IA.
The first is an IA. The subsequent petitions are writ petitions, my lord. The IA is Srimati Mosumi Sohoria. This order, this judgment is dated 28/9/2023. The fact, my lord, is at page 2, paragraph number 2. Line number 5 of paragraph number 2. In consideration thereof, an order dated so and so had been passed by the Director of Secondary Education, Assam, taking note that the writ petitioner, Sri so and so, had obtained her MA degree without obtaining a NOC or any previous permission from the appointing authority. Accordingly, it was viewed that the conduct of the writ petitioner, Srimati so and so, in obtaining the MA degree without the NOC or previous permission, which provides that no government servant, while in service, shall join or attend any educational institution for the purpose of preparing himself for, or shall appear at any examination of a recognized university or board without obtaining previous permission from the appointing authority. Thereafter, my lord, the findings of this honorable court is at page 6, paragraph number 6.
So what is the specific rule? Rule 13?
Rule 13 of the Assam Civil Services Conduct Rules.
In your case also?
In my case also.
Rule 13 was
Rule
quoted.
13. Rule 13 has been cited as the reason, my lord, for denying me the post of in charge of the principal. My lord, the finding of this honorable court is at page 4, paragraph number 6. Paragraph number 6, my lord.
Yes.
We are unable to accept the view formed by the DSC, Assam, in the order dated 27/7/2023, that as because the writ petitioner, Srimati Rekha Kolita, had obtained the MA degree without obtaining NOC or previous permission from the authority, therefore the MA degree of the writ petitioner would be unacceptable as per rule. From such point of view, the writ petitioner can be said to have made out a strong prima facie case against the order dated so and so. If the MA degree of the writ petitioner is otherwise valid and acceptable in law, the writ petitioner may have a legal right to be in charge, principal, and accordingly also has the benefit of balance of convenience, as well as will suffer irreparable loss if the interim order so and so is vacated. This was stay vacating order, my lord. Accordingly, the interlocutory application stands dismissed on being found without merit.
What is the reasoning otherwise?
The reasoning otherwise, my lord, is that
if it's valid and acceptable in law.
Yes, my lord, your lordship will kindly come to my submission.
Not your submission.
Yes, my lord.
This judgment.
The judge, my lord.
In the IA.
In the IA.
Why it was said that it's not what you call acceptable
No, the government authority, my lord, subject to it is for them to submit. What they've stated, my lord, is that Rule 13.
No, no, I'm talking about the court's judgment.
Yes, my lord.
Court say that if it's valid in law,
It is valid in
then
law. Yes.
why it should not be accepted?
Because
That much only.
That much only. Because there are subsequent orders also, my lord, where the entire ground is elaborated.
Then what will happen to Rule 13?
Rule 13, my lord, Rule 13 has been specifically dealt with in the matter of Tonkeshwar Nath subsequent case, my lord, where the Honorable Court has stated that if Rule 13 is not followed or adhered by an incumbent in prosecuting higher studies, that at the most would amount to a misconduct. That will be a misconduct.
Misconduct.
But that will not validate the degree otherwise that the petitioner has.
That will not validate or invalidate
The degree that the petitioner has obtained. Now, B.Ed is a primary requirement to hold the charge of principal on a regular basis.
That is in which case? In the subsequent case?
It's Tonkeshwar Nath, my lord.
Tonkeshwar Nath.
Yes, my lord. The facts are at paragraph number 2, and the findings, my lord, are at page 5, 6, 7, and 8, my lord. 5.
Paragraph 5.
5 onwards, my lord, at page 4. Your lordship is perusing Tonkeshwar Nath, my lord?
Yes.
Yes. Page 4, paragraph number 5. The provisions of Rule 13 of the Rules of 1965 mandates that no government employee while in service shall join or shall attend any educational institution for preparing himself or shall appear at an examination of a recognized board or university without obtaining previous permission from the appointing authority. The provisions of Rule 13 only mandates that prior permission shall be obtained by a government employee for prosecuting any course of study. The violation of Section 13, which should be ideally be Rule 13, my lord, would amount to misconduct for which the employer may draw disciplinary proceeding against the government employee. The provisions of Rule 13 of the Rules of 1965 cannot be invoked to invalidate any degree acquired by a government employee. The course of study for which the government employee had prosecuted without previous permission from the authorities.
Just read Rule 13.
Rule 13, my lord, is at page 4 itself, my lord.
Yes, read. Prosecution of studies.
Prosecution of studies by government servants in educational institutions. No government servant while in government service shall join or attend any educational institution for the purpose of preparing himself or shall appear at any examination of a recognized board or university without obtaining previous permission from the appointing authority. Provided that the appointing authority may refuse such permission in the interest of the public service on considerations that such joining or attending any education institution or appearing at any examination may create dislocation of work or stand in the way of the efficient discharge of his duties by the government servant concerned. Permission of study leave or any other kind of leave granted for the purpose of joining or attending any education institution shall be subject to the condition that the government servant shall not seek election or hold any electist office in students' union or other association of students except association formed for purely literary, academic, or athletic pursuits.
Okay, so if you violate Section 13, then what happens?
Then what happens is that, my lord, at the most that the authorities can proceed against me is on the ground of a misconduct, if at all. Now, in my case, my lord, what had happened is that I had obtained my B.Ed degree in the year 2013.
Have they proceeded against you for misconduct?
No, my lord. There has been no proceeding drawn against me, and in fact, a reasonable time of 12 years had passed, my lord. Now they're barred under law, my lord, by 4 years. 4 years have passed, my lord. In fact,
No, what do you mean they're barred?
They're not barred. In fact, what had happened, my lord, that the aspect of a reasonable time, my lord, pursuant to which and within which a departmental inquiry can be proceeded against, that reasonable period, my lord, had lapsed. In fact, in a similar matter.
What is is there any such kind of period prescribed?
My lord, in the Assam
Services.
pension service rules, my lord, the aspect of a period of 4 years after retirement of a government employee has been stated, but that law is applicable to when a government employee retires from service. Now, a reasonable period has passed, my lord, no departmental inquiry has been proceeded against.
So you're saying they're applying the same principle?
Plead that case if it comes to that, but the authorities have not proceeded against me.
Taking the same principle
I will argue that case
within 4 years, since nothing has happened.
Nothing has happened.
So they are barred.
Yes,
That's what he's saying.
That and if the conduct and the waiver of the authority, they're waived of that right, my lord. That authority cannot be given that option now. 12 years have passed since I had obtained my B.Ed degree. The only ground which they've taken was that I had not taken permission from the authorities or I've taken and obtained from NOC while I had obtained my B.Ed degree. That is the only ground which I have taken. And in fact, the gradation list, my lord, at page 17 and page 28 respectively indicate that I'm senior. I'm the senior most.
Anyway, see what can be done today.
What can be done today, my lord? Your lordship
Will issue
can
notice.
direct them to obtain instructions, or your lordship can.
Notice may go in this matter, your lordship. Notice
Definitely it
your
will go,
lordship.
but you are also to consider these aspects of the matter, because on the next date we may like to consider, we may like to go slightly deeper.
There are subsequent issues, there are subsequent judgments of this honorable court also, my lord. And the
Your lordship, pertaining to annexure K, your lordship, that is annexed in page number 45, your lordship. That one hearing has scheduled on very recent date, that is 4/6/2025 at 3 p.m. The outcome of this hearing, your lordship, I may obtain instruction pertaining to that.
Do that.
That is-
But in any case,
And your lordship, notice may go, your lordship.
notices can go, my lord, but the hearing cannot come to a different conclusion based on the sole ground which they've taken.
Your lordship, this is the on.
That is my humble submission, my lord. Now an additional ground will be taken.
No,
Mohinder
parties
sir.
don't get excited. You see, your case will go in its own
Yes,
rhythm.
absolutely.
Hearing will go in its own thing.
Absolutely.
Whether it comes this way or that way, that will be
Yes.
seen later on.
Yes.
As on today, we issue notice,
Yes, ma'am.
fix a date,
Yes, ma'am. Yes,
and take on board whatever you have submitted.
absolutely.
And Ms. P. Das will get us instruction regarding about that hearing, what has happened.
Annexure K, your lordship.
Okay. You are Mr.
M. Sharma, my lord.
Heard Mr. M. Sharma, learned counsel for the petitioner, who submits that the petitioner is aggrieved with the order dated 27/1/2023,
Yes, ma'am.
bracket annexure G, by which the respondent number 5
Yes, ma'am.
has been allowed to hold the charge of principal on in-charge basis in respect of TC Government Girls HS and MP School, Guwahati, with effect from 1/2/2023. Stop the learned counsel submits that there is no dispute to the fact that the petitioner is senior to the respondent number 5,
Right.
and that she is placed at serial number
68, my lord.
68 of the seniority list, while the respondent number 5 is at serial number 80.
80.
80.
80.
Stop the learned counsel submits that the petitioner has also submitted as many as 3 representations, which has not yielded any result till date. Stop. He, however, submits that a hearing was conducted on 4/6/2025 in the office chamber of the Deputy Director,
Deputy Director, my lord. Respond number?
Secondary Education,
Yes. Respond number 3.
bracket respondent number 3. But the outcome of the hearing is not known. Next para, the learned counsel submits that the grievance of the petitioner is fortified by a number of judgments rendered by this court which are as follows: colon dash, number 1, Roman 1, small Roman 1 within bracket. Okay. Judgment and order dated 28/9/2023 in IAC number
2615.
2615 of 2023. Open bracket, Srimati Moshumi Saharia versus Srimati Rekha Kalita and 3 others, close bracket.
Yes.
Then Roman 2. What are the other cases?
Tonkeshwar.
Okay.
Fine.
Just a minute.
Yes, ma'am.
Order dated 18/12/2023. Passed in WPC number 5419 of 2023.
Yes.
Open bracket. Tankeshwar Nath versus State of Assam and
Yes.
3 others.
Yes.
These 2 will do for the time being.
Yes, my lord. I've bought in additional 2 others as well.
Amongst others.
5419.
Put that also, amongst others, we'll stop. Next para, in view of above, issue notice, a motion returnable by 3 weeks.
23, no?
Ms. P. Das, Learned Standing Counsel, Secondary Education Department, accepts notice on behalf of respondent numbers
1, 2, 3, and 4.
1.
There is one private respondent 5 is.
Yes, 1 to 4. As such, formal notice is not required. Petitioner shall furnish requisite copies of the writ petition to the Learned Standing Counsel within 2 days. Stop. Petitioner shall take steps for service of notice upon respondent number 5 by registered post
Yes, my lord.
only, or
Yes, that should not be a problem.
okay, registered post with AD due within 3 working days. List the matter again on 6/8/2025. Learned Standing Counsel, Secondary Education Department shall obtain instructions as regards the status of hearing, which was said to have been conducted on 4/6/2025, as reflected herein above, by the next date.
I'm deeply aware. 16.
Yes.
But so the matter pertains to the provincialization of non-teaching staff, Lordship. That's if the provincialization of non-teaching staff is covered under the provisions of the Assam Education Provincialization Service of Non-Teaching of Fancy Education Institution Act 2018. So under this Act of 2018, documents were forwarded to the District Scrutiny Committee. But for a considerable period of time, Lordship, the grievance of the petitioner was not considered. So accordingly, he approached this honorable court, and this honorable court given direction. Lordship will find that court's order, page 30, annexure 10. The grievance is in the second paragraph. May I read, Lordship?
Yes.
Page 31. It is stated that the petitioner since 28/10/2010 he is serving as manual of Paharpo Katuli Ami Madrasa in the Baghbor Legislative Assembly constituency of District Barpeta, though the authorities concerned in the Elementary Education Department for the purpose of provincialization of service of non-teaching staff of said madrasa under the provisions of the Assam Education Provincialization of Services of Non-Teaching Staff of Hansar Educational Institution Act 2018 forwarded his name for provincialization, but on being inquired, the Director of Elementary Education Assam, by its communication dated 26/7/2022, informed the District Elementary Education Officer Barpeta that District Scrutiny Committee for Elementary Education Barpeta did not recommend his name for provincialization in said so-and-so school district Barpeta. So-and-so. Now next paragraph. Since the of direction, since the Director of Elementary Education Assam by letter dated 26/7/22 informed the DO Barpeta that the name of the petitioner was not recommended for provincialization of service by the District Scrutiny Committee for Elementary Education Barpeta under the Act of 2018, petitioner is directed to approach the Director of Elementary Education by preferring a statutory appeal under Section 8 of the Act so-and-so. So accordingly, Lordship, in compliance of this order at 12/12/2022, the petitioner preferred an appeal. That appeal, Lordship, find at page 11. The direction is given when the appeal is preferred, the Director will pass a region order. In next paragraph, in the event of filing the appeal, Director will pass the region order. So in compliance of this honorable court's direction, Lordship, he approached the authority, preferred this appeal, and on 20/12/2022. Now thereafter, during Lordship taking any decision, Lordship, page 12, annexure 35, the Director issued a notice to the DO, BO, and as well as the petitioner for hearing. This was issued on 19th of April 2022. 3. Annexure 12, page 35. Now, ultimately, Lordship, the district, it was the matter of the grievance of the petitioner was placed before the district scrutiny committee, and the district scrutiny committee recommended the service of the petitioner as grade 4 employee. So I have given the original copy and as well as the type copy, Annexure 13, page 37. This is the recommendation of the district scrutiny committee verbatim in respect of the petitioner Lordship from paragraph 5, bottom Lordship, Annexure 13, page 37. May I read Lordship? Paragraph 5. The matter, this is the recommendation. The matter of, this was done on 19th of January 2024. The meeting of the district scrutiny committee is 19th of January 2024. The matter of recommendation of Anwar Hussain, that is the petitioner, as grade 4 employee of so-and-so school in compliance of direction of the Honorable High Court passed on 12/12/2022 in connection with WBC so-and-so. During re-verification of records of the so-and-so school, it is revealed that earlier one Ali Hussain was working in the school, but he had resigned from service on 16/10/2010. On the other hand, Anwar Hussain had been appointed by the assembly of the school at grade 4 on 27/10/2010. But the headmaster of the school had wrongly included the name of Ali Hussain instead of Anwar Hussain in his application as grade 4 of the school, as well as the then district scrutiny committee had also recommended the name of Ali Hussain as grade 4 of the school as per Provincialization Act of 2018. Though the then DSC recommend the name of Ali Hussain, the government did not appoint Ali Hussain as grade 4 of the school, being information got regarding the anomaly. Therefore, the district scrutiny committee has decided to cancel the recommendation of Ali Hussain by the then district scrutiny committee and had decided to recommend the name of Anwar Hussain as grade 4 of so-and-so school. Now, decision. The district scrutiny committee has recommended the name of Anwar Hussain as grade 4 of so-and-so school, cancelling the recommendation of Ali Hussain being wrongly informed submitted by the headmaster of the school. Now, although the district scrutiny committee recommended the service of the petitioner, the grievance of the petitioner is yet to be placed before the state level scrutiny committee, because as per rule section 7 of the Provincialization Act of 2018, it says once the scrutiny is done by the district scrutiny committee, then it should be forwarded to the state level scrutiny committee for its approval. But here, Lordship, although the recommendation is made, it is yet to be placed before the state level scrutiny committee, and the director is the chairman of the state level scrutiny committee. So here, Lordship, I pray for direction to the director, Lordship, to consider the recommendation of the district scrutiny committee made by.
What is that provision? Section?
Section 7, Lordship.
Section 7 of?
Section 7 of this Act, Lordship.
Assam
Education Provincial, page 87, Lordship. Lordship will find a page 87. Starts from page 87. Name of the act is, Lordship got it, page 87. Assam Education, Provincialization of Services of Non-Teaching Staff, Cancer Educational Institution Act 2018. Now, section 7 says, District Scrutiny Committee. May I read, Lordship, from
Yes.
page 94?
Read.
The District Scrutiny Committee and State Level Scrutiny Committee as constituted under section 13 of the Assam Education Provincialization of Services and Reorganization of Educational Institution Act 2017 in each district and at the state level shall scrutinize service records. Now, already, Lordship, at the district level, this scrutiny is done. But so far, this at the state level, scrutiny is yet to be done. Shall scrutinize service records and other related issues of the non-teaching staff of venture educational institution for the purpose of provincialization of their services under this act. The list of non-teaching staff whose service shall be provincialized under this act shall be finalized in the manner prescribed under the aforesaid act. So, Lordship, it is the duty of
Aforesaid act means act of
this 2017.
17,
Because
right.
this state level scrutiny committee It was constituted as per this Act of 2017. And Lordship, kindly see, take up the Act of 2017, Section
Yes.
13.
Page,
Page, Lordship. Oh, it starts from page 99.
okay, see, before going further, anyone appearing for the other side? What do you say? Can we dispose it of?
No, my lord. If you lord the page 42, my lord.
Sorry?
Page of 42, my lord.
42.
42, my lord. The original copy of the decision, my lord.
What is there in 42?
The decision, my lord, the DSC has recommended the name of Anwar Hussain as grade 4 of Paharpur, MEM, cancelling the recommendation of Ali Hussain being wrongly informed, submitted by the headmaster of the school, my lord. Decision is this, my lord. And if your lordship go through by the tribe copy, my lord, page 38, my lord. The decision has recommended the name of DSC has recommended a name, my lord. After recommendation, my lord, whether it has been placed before the SLC or not, that instruction I may allow some time to take instruction.
My grievance is that it is yet to be placed as per the Act of 2017.
Today is the first day, my lord. Some time may be granted, my lord.
Because already since it has.
We can issue notice, but if the simple prayers that it should be considered by the DSC, I mean, by the state level committee, then we can also dispose it of in that line. And if already considered, they'll inform him.
So for a moment, kindly see the page 121 of the same book.
121.
Page 121. This is under the page 123 also. Because it says as per the Act of 2017, this state level scrutiny committee will be constituted. Now, how it will constitute is dear Lordship, page 123. This is under the Act of 2017. Both the acts are interrelated, Lordship.
Both acts are applicable.
Yes. Section 10.
They are in force.
Because so far this
it is in force. It is in force as on date.
Both are act is still in force. So what happened also under this 2017 Act, the service of the teaching staff is provincialized. But so far the non-teaching staff, there is a different act. This act is 2018. It is only in respect of non-teaching staff. But regarding the constitution of the scrutiny committee, it is as per the Act of 2017, page 123.
18 is for non-teaching staff.
Non-teaching
17 is for teaching.
For teaching staff.
Constitution of the district or state selection committee is provided in the 2017 Act.
17.
Okay.
So state level scrutiny committee, for a moment, kindly see page 123. There shall be one state level scrutiny committee in state level for verification of recommendation received from the district scrutiny committee. With the following member, namely, director is the chairman. So and so. So here also my grievance is that although recommendation is made by the DSC of Borbeta, the state level scrutiny yet to take a final call also.
No, this is the minute of 19/1/2024, my lord. 1 year has already gone by. That's why I'm praying for notice, my lord, at this stage.
No, notice may issue.
What will happen if notice?
They should get instruction whether it was placed before the state level committee or not.
Well, I will take instruction immediately after vacation.
Yes.
All right. Heard Mr. A. Dekal, learned counsel for the petitioner, who submits that this is the second time the petitioner is before this court. Stop. The first writ petition, being WPC number 7987 of 2022, was disposed of by order dated 12/12/2022 by directing the petitioner to file a statutory appeal before the Director of Elementary Education for provincialization of his services. So pursuant thereto, the petitioner's case was taken up by the District Scrutiny Committee, Borpeta, which held its meeting on 19/1/2024. And the finding was that the name of one Ali Hussein was wrongly included by the headmaster of the school instead of the petitioner. Therefore, the recommendation made in favor of Ali Hussein was withdrawn, and instead the petitioner was recommended for provincialization of his service. Despite the same, since the case of the petitioner has not been considered by the state level
scrutiny committee.
State level scrutiny committee. As required under the Assam Education, open bracket, provincialization of services of non-teaching staff of venture educational institutions, close bracket, Act, 2018.
Padamudi post is still lying vacant.
And as required to be constituted under the Assam Education, open bracket, provincialization of services of teachers and reorganization of educational institutions, close bracket, Act, 2017. The petition is before this court again. In view of above, next para, issue notice of motion returnable by 3 weeks. Ms. S. Sutia, Learned Standing Council, Elementary Education Department, accepts notice on behalf of respondent numbers
4 and 6 minutes.
1, 2, 3, 4, and 6.
5 is government.
5 minutes. I am doing.
This D.D. Burman, Learned Additional Senior Government Advocate, accepts notice on behalf of respondent number 5. So, as such, notice is complete upon the respondents. Petitioner to serve requisite copies of the writ petition to the learned councils appearing for the respondents today. This the matter again on 6/8/2025. On the next date, Learned Standing Council, Elementary Education Department, and the Learned Additional Senior Government Advocate shall obtain instructions and inform the court as to whether the case of the petitioner has been placed and considered by the state level scrutiny committee. Right.
17.
Your Lordship, the petitioner belongs to the persons of disability, Lordship. So pursuant to advertisement of 2018, 30th December 2018, he was appointed as grade 3 employee, Lordship. Lordship, make the first Annexa 1, page 12. This was the advertisement for grade 3 and grade 4. Recruitment, that is page 12, Annexa 1. 30th December 2018, recruitment for different posts of grade 3 and grade 4 reserved for persons with disabilities of different departments under the government of Assam. So in compliance of this advertisement, he applied. So ultimately he appointed. He was appointed as grade 3 employee, junior assistant. That appointment order, Lordship will find at page 31, Annexa 5. On 7th of November 2019,
where is that?
Page 31, Annexa 5. He is having locomotor disability of 50%. To that effect, certificate is also given. So this was the appointment order, 7th of November 2019. In pursuance of government letter so-and-so, regarding appointment of 19 numbers of junior assistant reserved for persons with disabilities of different provincialized.
Just a minute. You're reading from which page?
Page 31, Annexa 5.
Oh, 31.
From top, Lordship, order.
What is this order?
Oh, this is the appointment order.
Appointment order,
Yes.
okay.
My name is at serial number 6.
Good.
I was posted at Nagaon Girls College. serial number 6.
Hmm.
So thereafter I joined and continuing in service. So what happened, Lordship, pursuant to notification 2017, the disabled persons is allowed to get a disability allowance with effect from 2017. So accordingly, the college authority submitted proposal that Lordship will find it annexure 6 page 33. This was the first proposal. May I read, Lordship?
Yes.
2020, 7th of January 2020. This is from the college authority to the Director of Higher Education regarding grant of disability allowance of Sri so-and-so. With reference to the subject cited above, I have the honor to state that as per your approval, order number so-and-so 7/11/29, Sri so-and-so has joined this college as junior assistant reserved for person with disability on 11/11/2019. But sir, it may be mentioned here that Government of Assam Finance Audit and Fund Department has sanctioned disability allowance to differently able employees of the state government at the rate of rupees 1,000 per white gov notification of 19th of April 2017. As C.A. Das has been appointed to the post reserved for person with disability, I therefore request you kindly approve the payment of monthly for salary disability allowance of rupees so-and-so with effect from date of joining 11/11/2019. Now, ultimately, Lordship, pursuant to this, Lordship, the Health Department also, Lordship, given the approval that Lordship will find at page 34. With reference to the subject matter, I have the honor to recommend for the grant of disability allowance in terms of this notification to see Akhil Das, Junior Assistant of Nagaon Girls College. Annexure 7 is the disability certificate. There is no dispute that regarding any disability certificate. Now, ultimately, the director has issued the consequential order at Annexure 10, page 38.
Yes.
The
Then,
30th of June 2023.
so what is your grievance?
My grievance is that the benefit is given with effect from 2022. It should be from 2019, from the date of joining. That is my grievance. Because ultimately, let's see, although this order of 30th June 2023 was issued by the director, but effect was given from 3rd of February 2023. So later on, when he came to know, he then again issued this corrigendum. Next page, page 39. Here also now the effect is given from 20th May of 2022, but it should be from the date of joining.
Why this date, 20th May?
Lordship?
What is the purpose of this date,
They
20th
say
May?
that as per him, the application Lordship filed by the petitioner. That is
Oh.
not there. Lordship, kindly see the corrigendum. Please read the date of effect of disability allowance in respect of Akhil Chandra Das, Junior Assistant of Nagaon Girls College, as per his application that 20th May 2022 instead of 3rd of February 2023. But actually, this should be from the date of joining. And
Where is
already-
your application?
Lordship?
Where is your application?
Let's say actually application is moved from the college authority. College authority is given from the 2020 itself.
So 25 is the date of your application.
The date of application actually from 7th of January 2020 from the college authority. Proposal is routed from the college itself.
But they say that as per his application dated 25.
I told us I have not filed any application. Lord.
Sure.
I inquired me about this. Lord. He said that I am not aware whether I am entitled or not. But when I came to know about this order of 2023.
Your entitlement is based on the notification issued by the
Now,
finance.
Yes, Lordship, so far the date of effect in respect of other Lordship disabled person, it is given from the date of appointment. I have Lordship annexed a particular order, annex 13, page 41. This is in respect of Sri Pranav Das. He was the appointee of serial
Page?
number 1.
Page?
Page 41. Page 41. Disability allowance is hereby granted as per rules, as per not rules actually, as per that. So in respect of Pranav Das, Junior Assistant of Gurgaon College.
All right, will you notice this thing?
He was also appointed from the same appointment order in the 19, and the petitioner also has a serial number 6. He is at serial number 1.
Okay,
So Lordship, dispose of the order because
Notice
disability only the date of effect. In respect of others, it is admitted fact in terms of this 17 notification from the date of effect.
You can Lordship can dispose of.
Already director had issued the corrigendum also.
That's true, Lordship.
Mr. A. Dekar, learned counsel for the petitioner, who submits that the petitioner was appointed as
3651, no?
FB 3651.
junior assistant under the persons with disability category. Invite order dated 7/11/2019. So, as per the notification issued by the government,
It is referred at page 34. FM 7 2010, 19.
in the Finance, Public Audit and Fund Department. Dated 19/4/2017. Persons appointed under the PWD category are entitled to receive what do you call this?
Disability allowance.
Disability allowance at the rate of rupees 1,000 per month. Upon due recommendation made by the concerned authorities, the petitioner was granted the allowance, but only with effect from 3/2/2023. Provide order dated 36/2023, which was thereafter rectified as 25/2022. Provide corrigendum dated 15/10/2024. Staff the learned counsel submits that similarly situated persons who were also appointed along with the petitioner have been granted disability allowance with effect from date of joining of the post. To stop in this connection, the learned counsel refers to the order dated 14/8/2023, annexed to the writ petition as Annexure 13. To stop in view of above, issue notice of motion, terminable by 3 weeks. Mr. Ian Sharma.
S. Bhuya.
Sorry, Mr. S. Bhuya. Learned standing
Higher
counsel,
education. 1 and 2.
Higher Education Department accepts notice on behalf of respondent numbers
1 and 2.
1 and 2. Petitioner to take steps for service of notice upon respondent number 3 by registered post with ADD within 3 working days. Petitioner shall furnish requisite extra copies of the writ petition to Mr. S. Bhuya, Learned Standing Counsel, within 2 days. Place the matter again on so and so.
Item 18.
18 Lordship, same petitioner, facts are similar. Here Lordship is asking for transfer Lordship. Because as per this Disability Act of 2016.
Same petitioner.
Yes, section 20 and section 22. That's why I'm coming to this.
He's a very active person.
Not active Lordship. 50% is your certificate is given. That is why he is before your Lordship. So Annexure 7, page 44. That's due to his fellowship difficulties in carrying out the normal activities, he filed application before the Commissioner of Persons with Disabilities. Annexure 7, 4th of March 2021.
From where you want to get transferred?
From Nagaon to Nalbari. His hometown is Nalbari. Because the Act says, Lordship, the posting and transfer should be at the Lordship, native place Lordship. That was not done Lordship. So that's why also after joining in 2020, Lordship, he filed application before the Commissioner for Person with Disabilities. And
Where is your representation?
First representation, Lordship, I could not procure, Lordship.
Annexure 7
Annexure 7
is a forwarding
forwarding
letter.
letter from the Commissioner for Persons with Disabilities to the Director, forwarding of prayer petition, so-and-so juniors. May I read, Lordship? With reference to the subject above, I am forwarding herewith the petition along with other documents received from Sri so-and-so working as junior assistant, who is a person with disability regarding his transfer in his native place on disability ground, which is self-explanatory. It is to be mentioned that as per Government of India, WM number so-and-so 31st March 2014, persons with disability employees should be given preference in transfer and posting. Now, Lordship, will kindly come to page 66. This is the WM. Page 66, relevant portion, Lordship, will find at page 64. H, Lordship. Preference in transfer and posting. And this was not considered in terms of this office memorandum.
So what is the
Now, matter is now also pending before
present
the department.
status?
Lordship, matter is now pending before the department, Lordship. Not only the department and the social welfare department also.
Since when?
Since Lordship 2021.
Where was the last
Last
representation?
communication, Lordship, will find at page page 61, Annexure 22. This is from the Commissioner to the Joint Secretary of the Social Justice and Empowerment Department, 29th March 2025, regarding transfer. May I read, Lordship?
Yeah.
With reference to the subject cited above, I have the honor to state that the Right of Person with Disability Act 2018 attempts to address issues through various clauses. One of them is non-discrimination in employment of PWDs, persons with disabilities, and to that end, district as well as state, under section 20 to frame policies for posting and transfer of employees with disabilities specifically. This section 20, subsection 5 of the Act is 2016, is quoted below. 25, the appropriate government frame policies for posting and transfer of employees with disabilities. State government has to frame any policy till date, has not framed any policy till date to comply with the requirements of section 25 of the Rights of Person with Disability of 2016.
Okay, the petitioner is working under whom?
Actually, this
Junior assistant in the Nagaon Girls College.
Nagaon Girls College.
Okay, then he filed application before the commissioner.
Commissioner, Lordship, because this pursuant the advertisement of 2018, state recruitment in all the department. But although he has not preferred the education department, but the appointment order is issued in the education department.
Exactly, he should have preferred before the education
Yes,
department.
my preference, I have stated, my preference was agriculture department, irrigation department in my native place. But instead of considering those things, Lordship, I have been appointed in the education department at Nagaon. So that is why after joining.
Okay, after joining. No, please listen. After joining, you want transfer to your native place.
Native place, Nalwar.
Whom should you have filed the application before? Before whom?
Commissioner as well as the director higher also. There's a communication also.
But now it seems you have filed before the commissioner. And commissioner is forwarding it to the director.
Oh, right. In that before director also I filed.
You should have.
Page Annexure 8, page 45 also there.
Huh?
Annexure 8, page 45.
Yes.
After receiving my prayer petition, there only official communications are only going on also. This is from the director to the secretary, what to do. They're asking for instruction by this letter of 10th of September 2021. Thereafter, the wife of the application, Lordship, petitioner file application before the governor also in terms of this act. Annexure 9, 17 June 2022.
Is there any policy?
Yes.
Where is that?
No, policy is yet to be framed, Lordship.
That's why.
In terms of this office memorandum of 2014, as well as the section 20 and 21 of the RPW Act, the petitioner is supposed to place at the native place, but that was not considered. But
where is this office memorandum?
Office memorandum page 64, Lordship. It starts from page 62, relevant portion is at page 64.
So this OM is the policy.
Yes.
perhaps?
No, this is from the government of India also.
Government of
Most
India.
the state is concerned, they are supposed to frame a policy, but they have not framed any policy. Although there is a direction is given to frame policy. Annexure, it is the 14th law.
That is why nothing can be done.
Yes. Only communication is going on between the
At least that
departments.
notice you has to issue.
No, notice is issued, that is not. But so far, the
Yes,
lordship, they have not
is there.
complied the provisions of the act.
Notice, this is a notice, lordship.
Lordship, for a moment, kindly see page 64. Preference in transfer and posting. Nothing, two lots.
What can be done at this stage? Will issue notice?
Please not go, or let them have instruction on the status of the transfer.
No, will issue notice, that's
Yes.
better.
No, notice may issue. Lordship.
And
Understand,
Mr. A.
sir.
Das,
They should obtain instruction.
learned counsel for the petitioner, who submits that the grievance of the petitioner is that although he belongs to the PWD category and he has been appointed and posted as junior assistant in Nogaon Girls College, Nogaon, despite giving his preference to be appointed under
Agriculture, page 4, page 7,
agriculture,
agriculture department, irrigation department, and PWD department. I have stated.
under agriculture, comma, irrigation or PWD
Department.
department. No, Public Works Department.
Public works.
In the district of
Nalwar.
Nalbari. To stop, the petitioner has submitted several applications for being posted to his native place in Nalbari, but the same has not been considered till date for want of a policy to be framed by the state government. To stop, the learned counsel submits that
So
the government of
policies under
India,
sorry to interrupt, policies under the RPW Act, Right of Persons with Disability Act, 2016.
okay,
That
what
may
did I
be
say? For want of, then you continue, state government under the right to,
Right of Persons.
right of persons with
Disability Act,
Disability Act
2016.
2016. To stop, the learned counsel submits that the government of India in the Ministry of Personnel, Public Grievance and Pensions, Department of Personnel and Training, White Office Memorandum dated 31/3/2014 has already incorporated preference of transfer and posting in case of persons with disability. Stop. By invoking the same principle, the respondent authorities should be directed to consider the case of the petitioner for posting in the
Governmental
Nalbari
authority.
district.
Governmental.
Next para, in view of above, issue notice of motion returnable by
Governmental.
4 weeks. Mr.
আপোনালোকৰ
S. Bhuya, Learned Standing Council Head, Education Department, accepts notice on behalf of respondent numbers. One,
One and
two, one and two.
one and two, lord.
1 and 2. Who will be there for social justice?
Although there is a standing council, but notice is accepted by the government.
Huh?
For 3 and 4, there is a standing council, but the notice accepted by the government is their lordship.
There is separate standing, RM Das is.
Yeah, I will serve extra copy lordship. 3 and 4.
Notice be served to respondent numbers 3 and 4 by standing council. Huh?
5 also government. Commissioner for Person with Disability,
RM Das will appear for 3 and 4, is
3
it?
and 4.
We serve to the respondent number 3 and 4 through standing council, Social Justice and Empowerment Department, Mr. RM Das, within 2 days. Stop, the acknowledgement of Mr. RM Das be filed before the registry. Then
Five is government.
Ms. Burman, you'll appear for 5.
Yes.
Ms. D.D. Burman, learned additional senior government advocate, accepts notice on behalf of respondent number 5.
Six and seven.
Petitioner shall take steps for service of notice upon the respondent numbers 6 and 7 by registered post with ADU within 3 working days. The sub petitioner shall furnish requisite copies of the writ petition to the learned counsels appearing today. List the matter again on so and so. 8. The Mr. S. Bhuyan, learned standing counsel, Higher Education Department, shall inform the court about the status of the. Who will consider thing? Your
Director as well as the Lordship, the Social Welfare Department, because so far the
status of
last
the
communication-
consideration of the application of the petitioner for his transfer by the next stage.
the concerned respondent.
Who else will be there? Mr. Bhuyan will take instructions.
Lots.
I think that should do.
Lots.
Lots.
Here is vacancy is also there. I have taken the information from my native place, MNC Balika Vidyal College.
It's up to you. You may
Yes.
file additional affidavit. We can
It is
think
there,
of
but I have
considering. Hmm. Senior most eligible what? 4?
And this rate of graduate stage is 1990.
Yes.
The date of getting my graduate stage is 30/12/1990. So let's find the right side. That 18 given. And the page number 20 or should be fine.
Just a minute. Where is that 3012? Hmm? What is the name? Jitendra. Tankeshwar Nath. He's the petitioner. What is this date? 30? Hmm. What is this date? Graduate scale. Okay. What is he? Graduate teacher.
Till number 4, Rahul Das is date of getting graduate stage is 5/9/2009.
Serial number, page number?
Page number 25.
Hmm.
Till number 4.
Same page. No, 22. Serial number 4. Who is Ratul Das? Number? Respondent number 4. Five nine 2009.
But my lord, the post of people have fallen vacant on 31 1/4/2023, and an acceptable or should be fine by order dated 30/3/2023, page number 25 PC, whereby one junior teacher was given the charge of the principal of the school matter.
Page number?
Page number 25.
Hmm.
Party 3/2020. This order was put to challenge if
on writ petition.
Who is the person here named? Jitendra Chandra Brahman. He is not a party here. Okay. This was put to challenge. By whom?
Court, my lord, but order dated, my lord, 9/10/2020, just prior to the order.
Why is not annexed here in your writ petition?
The order was given with respect with regard to my lord, earlier appeal order 33/2023 annexed. And ultimately, the six level court, by order dated 8/3/2023. This is the annexure 3. Page, which starts from 26. 11 portion, my lord, is 31. Paragraph 10. According to the matter stands remanded text. Page 31. This appeal order is set up and is remanded back to the Director Secondary Education. Accordingly, the matter stands remanded back to the Director Secondary Education Department, who shall now pass appropriate orders allowing the petitioner, Mandamas is given to hold the charge of the post of principal Satyabari Higher Secondary School Satyabari after due verification of the particulars of all the candidates in the state.
Pankeshwar Nath is the petitioner.
Yes.
This is the second round.
After that, my lord, after order, in the name of compliance, my lord, and compliance order is.
Just a minute. Just a minute. What is the first case?
5419.
What was the direction?
There was to allow me to hold the post of the principal.
Where's the final order?
Final.
Then?
Then, my lord, they have passed another review order, annexure 4, page 33, my lord, whereby they have, my lord, again rejected my claim and directed the inspector of justice to proceed with the disciplinary proceedings against me, page 35. Direction.
What was the direction of this court? To ask you, to allow you to hold charge?
That they have compliant and they have rather directed the inspector of justice to proceed against me. And I have put to challenge this case also, this order also, my lord, in
What?
the subsequent case.
Okay, where is the order? Page 33. What is the date?
Because by 2024, that was the investment. It was also said initially in WPC 2133/2024 by order dated 22/4/2024. It was stated.
Oh, just read the relevant portion of this order. Page 33. Page 33. Please go in a sequence manner, okay? Don't take me here and there.
In view of the above fact and finding, the MA degree acquired by the petitioner Dr. Nath, assistant teacher, in the year 2016, during his service period from KKHSOU, is a valid degree. First, the Dr. Nath, assistant teacher, has made a misconduct by not obtaining previous permission from the appointing authority for that purpose, as per Rule 13 of Assam Civil Service Conduct Rules 1965, and thus he is liable to be proceeded departmentally by the departmental authority as per provisions of the Assam Civil Services Disciplinary Rules 1964. Therefore, the Inspector of Schools BDC for PETA, being the appointing disciplinary authority in respect of assistant teacher of Provincialized secondary school, is hereby directed to draw departmental proceedings against the petitioner, the Dr. Nath. Hereby direct Dr. Nath, assistant teacher of Satyabari school, immediately and conclude the same within the stipulated time as per provision provided in the Assam Services Discipline Appeal Rules of 1964.
But the direction of this court was to give you charge.
Yes, that was not clear. That they have directed to my lord, proceed against me.
Disciplinary proceeding. Then
That
you
yeah,
challenge. Just a minute. Put to challenge by which case? Which case? This is the final order. Annexure 5. What is the operative?
page number page 41.
41.
41. It down certain parameters in cases, in certain cases where NOP has not been obtained and the degrees have been proposed by the concerned teacher. Certain parameters are given as paragraph 11. My lord, may I read, sir?
Read.
Permission to prosecute studies by a government servant in an educational institution is a sine qua non in terms of Rule 13 of the Rules 1965. Such permission can be refused in terms of the provision to Rule 13 of the Rules Rules 1965. While such prosecution creates disallocation of work and stands in the way of efficient discharge of duties by the government servant and leaves a big gaps in the working strength. The object of rejection of scheduled institutions, Schedule 3, for pursuing higher studies through distance mode is to facilitate the serving teachers to acquire the required professional and educational qualification, so that the standard of imparting education is maintained without hampering regular classes of schools and without disturbing the day-to-day work. A conjoint reading of both the Rules 13 of the Rules 1965 as well as Schedule 3 of the Rules 2018 and the discrimination as recorded herein above leave no room of doubt in the mind of this court that prosecuting higher studies by serving teachers without permission from the scheduled institutions as enumerated under Schedule 3 of the Rules 2018 cannot be termed as a misconduct in terms of Rule 13 of the Rules 1965. Permission mandated under Rule 13 of the Rules 1965 cannot be made applicable in prosecuting studies by teachers whose service conditions are controlled by the Rules 2018 through distance mode from the scheduled universities institutions enumerated under the Schedule 3 of the Rules 2018. Determination made in Moshami Shahoria Supra cannot be termed as any direction to the authorities in education department to initiate departmental proceedings against all teachers who prosecuted studies for distance mode from the scheduled institutions incorporated in Schedule 3 of the Rules 2018. While there is no dispute that the petitioners had obtained their degrees through distance mode from KKHSOU, Idle, Guwahati University, Dibrugarh University, and Assam University, in terms of participation made under poem dated 28/7/2014 and poem dated 22/11/2019. Therefore, Rule 13 of the Rules 1965 cannot be made applicable to these teachers taking clue from the observation made in paragraph 4 of Moshami Shahoria Supra. Accordingly, in any proceeding has already been initiated against the petitioner during the pendency of these three petitions, the same shall fail. In the considered opinion of this court, the determination made in WPC 4205/2024 and WPC 1680/2024 clearly covers the case of the petitioner in as much as the issue is related to prosecute higher studies through distance mode. Accordingly, in view of the determination made in WPC and another connected with petition, the impugned order dated 7/4/2024 in WPC number 2136/2024, the communications dated 10/7/2024 and 11/7/2024 in WPC number 3917/2024, and the proposed notice dated 19/4/2024 in WPC number 5653/2024 being not sustainable are set aside and quashed. With the aforesaid observation and directions, this declaration can close without interfering in the communication.
This is the second read petition.
Yes.
Then thereafter, what happened? Yes.
First one, challenging the order of the director and by the Shokos notice individual issued by or 19/4/2024.
These all are your writ petitions. Okay.
And in compliance of this order, my lord.
But what is the direction?
Direction. The improved proceedings whatever issued in pursuance to the order dated 10/7/2024 is set aside.
7-4.
Yes, that order is passed in compliance of the earlier direction of this honorable court.
Correct. 7-4 is set aside.
Yes,
Now, what is the further direction from this court?
then this first direction is not further direction, it's the final order.
So what is to be done now?
My lord, whatever is compliant
After disposal of the secondary petition?
order. At page 45, you will find.
Oh, after order was passed in the second writ petition,
Yes.
what remains? What remains is the order passed in the first writ petition to give you charge. Correct.
That is-
Then
At page 45, when I'm reading paragraph is above, the last, from the bottom,
what is page 44?
page 44 order and of this case.
Relating to which case?
Of that. Dated 11/4/2020.
But there's no such kind of direction given in that case. They simply set aside, that's all.
And my lord, I have tried to give the charge which, with regard to the earlier order. first
Court
order.
has already set aside.
Yes,
Then director again has to set aside the same order. What is the requirement? He's already set aside.
that's the first term, my lord. They have rejected this time also at page 45 from the first paragraph from the bottom. What they have done, my lord? They have taken into my age eligibility on the on 1/1/2025. Instead of taking my eligibility with effect from 1/4/2023, while the post has fallen vacant. The post of principal has fallen vacant on 1/4/2023. On that date, my lord, I was below 57 years of age and I was eligible qualified in all respects. And this is only due to their administrative atrocities, my lord, I was not given the chance. But given my findings, my lord, paragraph 3 from the bottom. Whereas the date of birth of the petitioner, namely Sri Tonkeshwar Nath, is 3/1/1967. And as such, as per date of birth, the age of petitioner as on 1/1/2025 is 57 years 10 months. And thus he does not fulfill the aforesaid criteria for holding the charge of principal of Sotyabar HS School as on date. This is the ground they have taken.
Okay, what is the criteria regarding date?
Correct. But the course of action arose in the year 2023 with effect of 1/4.
You fail to explain. Don't think that I know all the parameters. You have failed to explain why you have not qualified. Is there any restriction, any guidelines that you have to be at a certain age? Yes, what does it say?
It says one must be at the 57 years. One should not cross the age of 57.
It should not be more than 57. So that's why you have been barred. So explain that. Straight away you're saying that because of this. So you have crossed 57 years by 10 months.
125. But my submission is that, my lord, the cause of action arose in the year on 1/4/2023. And only for their, my lord, they are deprived.
Cause of action in 23. So you are seeking in charge since 2023. Can you go back?
I was not given the chance. Otherwise, I am qualified. This one for repeatedly, my lord has held that and directed if the authorities were to allow me, my lord.
So what is the ultimate, what is the conclusion? No, the conclusion in the order, the impugn order.
They have given a chance, the respondent number 4, my lord. And in view of the above paragraph for the second paragraph in page number 46 and reading matter. In view of the above, in the interest of public service, Sri Rakul Das, MA, BS, post-graduate teacher receiving post-graduate age of 8 is hereby temporarily allowed to act as principal in charge of the same school in addition to his normal duties. This is the order.
Yes, who's appearing? Hmm.
After the order that was passed by the Honorable Court, setting aside all this, the impugned supers notices,
Hmm.
the disciplinary proceeding, there was no requirement for passing any order.
Hmm.
It has a reflection in the order, but basically this order was passed on an application that was made by the petitioner, claiming for giving him the charge of principal. Your Lordship,
Hmm.
can you see page 45?
45, yes.
6th paragraph from the order.
6 lines, you say?
6th paragraph.
6 paragraph. Page 46
Page 45.
or 45.
6th paragraph.
Hmm.
Order.
Hmm.
Order in regard to the prayer submitted by the petitioner, allowing him to act as the principal in charge by this petition dated so, it is observed that.
Hmm.
It is observed that Rule 212, Subrule 3, Roman 5.
That we just read, 57 years, not more than 57 years. No, but he says that if you go by that 2023, I was eligible.
Every element of this Rule 12.5, Roman 5, has to be read with Subrule 5, Roman 1. Because every end of every year, the inspector is required to identify where are the vacancies available.
Okay, tell me one thing. This is the third round, isn't it? The first time they came at page 26. Court said that give him, allow him to hold the charge.
That was in a different context, right? At that point of time, as the charge was not given to him on the ground that he had obtained his degree without permission. In violation of-
See, Mr. Kaushik, that we are aware of. Whatever it may be, court said, give him the charge. Instead, now you have made a roving inquiry. How he's got the qualification and this and that. Then you say that he should be proceeded against under Rule 13 because he has not taken permission for getting that B.Ed degree. And that he challenged again. That was set aside. Thereafter, again, you pass one more order at page 44.
Page 44
Now you take another excuse saying that
his application.
oh,
Now, while considering his application has to be considered within the corners of the statutory rules.
so
The 2018 rule is the rule.
the the mentions of all these sequence of events before what you just read, it was not necessary. So what is necessary is to consider his application. And you say that on consider his application, the statutes provides that you can't be more than 57. So that is the reason why. Then what will happen of this, the first order? The first order, what will happen of that?
He has lost his force.
Yes, has lost his force.
Because of his being ineligible for becoming the principal in terms of Rule 12.
And what is that date you're relying upon? 2023? Why? What is that date?
That date
1/4/2023. Post has fallen vacant. So question is, can we go back to that stage? That will have to be examined. On that note, we issue notice. We can't go beyond that now. Hmm. Who is holding charge?
I did
I don't think so.
before
cannot have both in multiple issue notice in the brief and also notice and interim. In every case, this mallet is
There's a
practice
practice
grant interim order has given all the interim before your lordship. In every case, this mallet, this Supreme Court has given protection from the day one.
Despite that, you have not got any relief.
They are, my
So
lord,
what is the point?
They are only at their fault, my lord. They are intentionally harassing, nothing but harassment and atrocity.
We'll thrash it out at the next court date. Today we'll issue notice. Today notice will go only, all right? Heard Mr. B. Prakash, learned counsel for the petitioner, who submits that this is the third time the petition is before this court. Of the first writ petition being WPC number 5419 of 2023 was disposed of by order dated 18/12/2023 by directing the respondent authorities to allow the petitioner to hold in charge principal of, what is the institution? Where do we get that? Okay. Sarthebari Higher Secondary School, Sarthebari. After due verification of the particulars of all candidates in the pipeline. Stop. Pursuant to that, the respondent authorities concerned passed an order dated 7/4/2024 denying the petitioner from holding the charge of principal on the ground that he did not obtain prior permission for obtaining B.Ed degree and thereby violated Rule 13 of the Assam Civil Service bracket conduct close bracket rules 1985. Stop assailing the same, the petitioner filed the second writ petition, that is WPC number 2136 of 2024. And the same came up for final consideration on 11/4/2025, wherein the other writ petitions filed by the petitioner in the meantime, that is WPC 3917 of 2024 and WPC number 2653 of 2024 were also disposed of by the same order. Stop. In respect of WPC number 2163 of 2024, the impugn order challenge, that is order dated 7/4/2024, was set aside. Stop. After the disposal of the aforesaid writ petitions, the respondent authority concerned passed the order dated 21/6/2025 bracket annexure 6, by which it has been held that the petitioner has crossed the age of 57 years, which is the maximum age limit for holding the post of principal, by 10 months, and accordingly not eligible to hold the post of principal. To stop, the said order has been challenged in the instant writ petition. Next, the learned counsel for the petitioner submits that despite passing of various interim orders in favor of the writ petitioner, the respondent authorities, for one reason or the other, has deprived the petitioner from holding the charge of principal of the said school since the day it fell vacant, that is 1/4/2023. Stop. Therefore, the contention that the petitioner by now is overaged to hold the said post on in charge basis is not sustainable. Stop. Next para, considering the above projection made by the petitioner, a thorough examination of the matter requires to be made. In view of above, issue notice of motion returnable by 3 weeks. Mr. B. Kaushik, learned standing counsel, higher education, correct?
Second.
Secondary education accepts notice on behalf of respondent numbers 1, 2, and 3. Petitioner shall serve requisite copies of the writ petition to Mr. B. Kaushik within 2 days. Petitioner to take steps for service of notice upon respondent number 4 by registered post with ADDU within 3 working days. This is the matter again on so and so.
11(8). Come along with the application of 2003 of 2025.
Why?
That is also filed by the petitioner.
For what?
Also with regard to LOP increase of care.
NOC.
He has been deprived for recommending for the post of headmaster.
No, NOC will be given by whom? For what purpose?
As because he has not procured NOC, he has been rejected.
NOC to undergo training, BA training, MA training. What is the case number? 2003 of 2025. What is the stage? Okay, list the case again on so and so. Give the date is there, na? Along with WPC number 2003 of 2025. Or that this stage. We'll examine. Prayer for interim shall be considered on the next returnable date.
11(8). Item 20.
Appointment letter for he was joined in the year 2004. 2004.
Where's the order?
Page 21.
Petitioner's appointment order. Is it appointment? Appointment as what? What is the date?
Permitted to therefore, you are permitted to take classes regularly from before 10/1/2004.
Date of the appointment. Date of appointment.
Dated 1/1/2000.
Is it like that? In the vernacular? Vernacular? No date is given. Separate date is not given.
5 is created joint. Then what happened in this case, the school was provincialized in the year 2013.
2013.
Yes. Just status report for 20 pages, annexus 6, page 25. Her name is Abida Begum. At the time, she was first in higher secondary.
Page 20.
Just status report as per dice 2009.
Abida Begum.
Is there the dice book. Then also condition page 57. 38. Teachers have been created under provision of the Assam Education Institution 2012 service of the Qualification. The other books selected schedule for the post of the proposal of district elementary. Now, for 145 appointments, equal scale pay as a district. WA 2030 under provision of Central Education Institute. And her name is shown, madam, but it is written that two posts due again due to under qualification. It is shown that I was underqualified. Then lawsuits can be done if 28 madam.
Where is it shown that you are underqualified?
Please. That's the thing.
Where's that? Not legible. Where?
That is 27.
27. Where is your name?
My name is not shown. It is shown that to post at again into under qualification. Then lordship turn page 30 to be your lordship can understand that local unity execution officer forwarded letter to be immediately since it is not written that it is post again into under qualification. See file an application that is subject to petition of Miss Abida Begum. Abida Begum is the petitioner. Then he forwarded letter to the district elementary education officer in the year 23/12/2014, which refers to the subject cited above. I have the honor to forward the original application of Mrs. Abida Begum forwarded by Mrs. Samsunahar Ekondita of the King Monetary Balok LP School, which speak itself with the documents. Then your lordship kindly turn page 31. Then district elementary education officer forwarded a letter to the director of elementary education officer 4/2/2015. Forwarding subject is that forwarding an application in original in respect of Miss Abida Begum, King Monetary Balok LP School, which refers to the cited above. I have honored to forward here with an application along with other documents in respect of Abida Begum, assistant teacher, King Monetary Balok LP School, claim for provincialization of a service has received from Lahoriga High Metro number under reference to against the vacant post in the school into under qualification as per your provincialization order. That is 16/5/2013.
So what is to be done? You are underqualified. No, you are underqualified, they say.
By the district elementary.
Where's that? What does it say? What does it say?
One and three is the my
Then why do they show at page 27 and next page that 2 posts are vacant because of underqualification? The other post was occupied by you. No, but they say, but they say you are not qualified, underqualified.
Consist of application, this correspondence are here.
Let's see page 33. What is this? Hmm.
Which refers to the cited above, I have honor to inform you that one, the King Monetary Balok LP School was provincialized as per above mentioned order, which one post, though 2 posts were sanctioned against the school, but 1 post that Miss Abida Begum was not released due to her underqualified.
So you were not HSSLC pass. Later on you pass. Later on you pass. Earlier you were not passed. This is what the letter says. Please read, continue. Sir, at present, read. Later on you pass. This is your own document. That's what I'm saying. 2013, they found that 2 posts is vacant due to underqualified. Now in 2020,
Qualified now.
now she's qualified now. Earlier not qualified. So there was some error at the time of provincialization.
qualified or not at the time of provincialization.
But this letter is already there. Already in 2020.
The application. Notice may go over at this stage and let them bring instructions.
Please read your representation at page 34. Let's see. With due respect, I would. Hmm.
I joined on 5/4. I passed higher secondary examination in the year 2012, but school was provincialized 2013, madam. And thereafter, I also completed diploma of DLA in the year 2017 and 19. I have an exception. The said school was provincialized on 16/5/2013, but my name was not shown in the list. It is shown as a vacant post due to underqualified, which is not correct. So my name is shown in the dice code 9 and 20, 9 and 10. There immediately I filed one petition for the DO, Morigao, on 26/6/2000, District Elementary Education Officer Morigao submitted a proposal to regularize the service of the petitioner as a teacher in the school of Dr. Morigao, Morigao to Director Elementary Education Officer, but till today nothing has been done. This is my pair. This is the case. This is my case. So it is duty to the director to correct the error, my lord, and let the petitioner be permitted.
Any instructions? You get instructions on this. We issue notice. Pardon, Ms. K. Devi, learned counsel for the petitioner, who submits that the petitioner was appointed in Dakhin Moritoli Balak LP School by the managing committee as assistant teacher, which she joined on 5/1/2004. Stop. The petitioner passed her high secondary examination in the year 2012 and also completed diploma elementary education in the year 2017-2019. 34 you'll get, page 34, these facts. Stop. Although the school was provincialized on 16/5/2013, but the petitioner was left out. And it was shown that the posts have been left vacant due to underqualification. So according to the petitioner, her name is shown in the DICE 2009-2010 and also in 2010 and 2011 of the SSA Morigao. Stop. Her representation was also forwarded by the District Elementary Education Officer Morigao to the Director of Elementary Education, Assam, on 26/6/2020. But as the same has not been considered and relief granted to the petitioner is before this court. Stop. The learned counsel submits that the petitioner had filed a representation on 19/6/2025, bracket annexure 13, and which remains unconsidered till date. Stop. Next para, Mr. B. Kaushik, learned counsel, standing counsel, Elementary Education Department, appearing for the respondent numbers 1, 2, and 3. 1, 2, 3, and 4.
Yes.
Who's there? One. Okay, we'll take your name only. You are for respondent numbers 1, 1, 2, 3, and 4. Submits that since the representation of the petitioner is pending before the Director of Elementary Education Officer, the same may be directed to be considered. Stop. Having regard to the projection made by the petitioner, and particularly the pending representation submitted by him on 19/6/2025. The writ petition is disposed of with the direction to the respondent number, with the direction to the Director of Elementary Education. Respondent number, bracket respondent number 2, to consider and dispose of the representation of the petitioner as expeditiously as possible and preferably within a period of 6 weeks from the date of receipt of certified copy of this order. Yes.
No pre-appointments have been made because they, both this line came.
That is not your prayer.
Here is there, here is there. In the engineering house, can it be? In order writing the respondent copy, upon any fresh appointment, this school of the thing will be ballot casted.
Shall we make it 4 weeks then? 4 weeks. This representation.
Nothing will happen. That is why I want the engineering pair. It is still lying again, mother.
Let the representation be considered for the under the 2017.
Yes, I have no objection.
No, that the director will be well conversant with that. We did not tell him how it is to be considered.
Pending because the legal step. So, in the year 2020, the sentence of that, it is a line again. You go to the condition.
Yes, Devi, let it remain like that. We'll make it 4 weeks instead of 6 weeks. Okay. No further observation. The petitioner should also submit a copy of the writ petition along with a certified copy of this order before the respondent number 2 for doing the needful.
For orders, item 28.
The radio petition. What has happened here, the summary of the case is very limited. While provincialized under the House of 11 Act. Now provincialization order can also be issued. But we have subsequently been one of the authority who has no power to cancel the provincialization order because it's like out our provincialization. Now that cannot be put into challenge in the first round of petition maker, but that in that petition maker.
Yeah, you take me to the order first, straight away. Which you want to review? 45. So what is wrong in this order?
On that day, because in my absence, one of my colleagues is but they have not used that. That is one wrong, and the extraordinary trade court setting aside and crossing the order is the 8/6/2010. Issued by the respondent and pursuing the director of Union whereby the provincialization of service of the petitioner has been unilaterally withdrawn without giving any opportunity of being heard and further to direct the respondent authority to allow them to continue in service and to release the salary with all other benefits of the government servant as well as not to recover the salary already drawn by them.
Please simplify. This is a review petition, not a writ petition. So you have to point out this is the order and what is wrong, what is the error apparent on the face of the record, We cannot go for a full-fledged hearing again. It's not rehearing. You know very well. So tell me, just simplify things. This is wrong, that is wrong, it should have been like that. Hmm. Paragraph 7. Yes.
Or sanctioning of the two posts against the name of the petitioner passed as disposed by an order dated last week, and struck down the Concerned Educational Provincialization Act 2011. The government could not sanction the post for provincialization of services of the petition, and now the district elementary officer Guwahati has submitted a further recommendation of the OSC under the new Assam Educational Transfer Act of 2017 for provincialization of services of the petition. Mr. Sharma therefore submitted the case of the petitioner may be considered along with the other similarly situated candidates along with the provision of the said act in due course of the process which is on. Mr. Sharma has submitted that she addressed in this figure statement report. Similar to the finding at the last paragraph at page 12. Having given the access consideration of the amendments made in the petition supported by the document annexed thereto and hearing the learned counsel for the both sides, it is provided that as the petitioner's names have already been recommended by the DLSC for provincialization of their services, the respondents, more particularly the respondent number 2, the Director of Elementary Education Assam, Ahilapura shall consider the case of the petitioner under the provision of the so-and-so Act of 2017 as expeditiously as possible, preferably within a period of 4 months from the date of receipt of a certified copy of the order. But our case was not that. If we did not want that our case should be considered under the 2017, our pleaded case was that as the provincialization which has been done under the 2011 Act, that cannot be interfered with by without following the due procedure of law. Once I have been provincialized, I have attained the the position and the definition under the government employee. So that was our pleaded case. Now, therefore, the procedure which is required, if it is required to be withdrawn, an opportunity of hearing, as well as the Assam Service Discipline and Appeal Rules 1964 was required to be invoked. But the authorities, without following the due process of law, suddenly strike out our provincialization. That has not been,
Your provincialization under which act? Your services have been provincialized as what? Teachers or assistant teachers? Teachers of which school? No, what level? Teachers of elementary school. Okay, then you were provincialized under what provision? Act of 2013. So now what was your case in the writ petition?
Our provincialization without following the due process of law.
No, your provincialization was struck off. When?
Page 39, annexure 8. Page 39, the service of the provincialization order in respect of the Nanila Busumotari assistant teacher and the Mahendra Busumotari assistant teacher of Alapara, Sonapara LP School under Gwalpara district issued by the office order memo number so-and-so is hereby withdrawn. But this is absolutely not permissible under the law. So this was our pleaded case, in the writ petition, but the matter went otherwise, that we have been directed to be considered as fresh under the new Act of 2017. Because similarly situated employees who were provincialized under the 2013 Act have also been protected by the division bench of this honorable court in a review petition filed by the state.
Do you have the provincialization order?
The order in pursuance of the government letter number, whereby 406 posts of assistant teachers have been created under the provision of the Assam Branch Educational Institutions Act of 2011, amended in 2012. The services of the following eligible employees are hereby provincialized and allotted category of posts at the disposal of the District Elementary Education Officer, Qualification, or school, lower primary school, the usual scale of pay, as admissible from time to time with effect from so under the provision of the Assam Branch Educational Institution, Provincialization of Services Act 2011, amended in 2012. The category was made up of posts as follows. Now, our name, my lord, please page 27. And I'm sorry, same example.
Where is your name?
Yes, sir. Manila Basumatari is at serial number 3, 27. And Mohesha Basumatari, they are also 4.
There are three, petition number 1.
That's serial number 3, That's serial number 4.
No, exactly. So this is the provincialization order. But it does not say about the 2013 Act. It says 11 Act. Ah, that's what.
This 2011 Act virus has been put into challenge before the Honorable Court. And the Honorable Division Bench has strike out, admittedly strike out.
Okay.
After our provincialization, not before our provincialization. While striking out, the entire state from a direction to the state that they should come up with a fresh legislation, and thereafter 2017 legislation has been enacted.
So are you saying that the striking out of this 2011 Act was prospective, not retrospective? So you should not be affected. But nevertheless, you have been, your provincialization has been withdrawn. So that was your case before the writ court. Then ultimately the writ court decided that your case should be considered under the. Now, what is that 2017 Act? No, 2017 Act has replaced 2011. After it was set aside, 2017 Act has been enacted. So what is wrong in that?
Now, once this our provincialization has been strike out, we are not getting the benefit from 1/1/2013. That has been wiped out. But similarly situated employees, who were provincialized under the 2011 Act, till date, they are not disturbed, they are working. Because of an order passed by the Honorable Division.
What is that 1 of 2013?
By which all employees have been provincialized in the effect date.
As page 26, as regards. Okay. Now, after the order passed by this court, have you been considered for provincialization as per the 2017 Act? Why I'm asking you is that it could have gone in 2 stages. First, let them abide by the direction. Once you get the provincialization under 2017, you can say that, see, I had the benefit since 2013. I should be getting that benefit from this date. That could have been decided separately. Instead, you've come in a review. Now, what has transpired in with?
Review consideration is very limited. When there is
No, I'm not talking about the scope of review. I'm telling you that the course of action which you ought to have been taken by the review petitioners is that since that order was passed, you wait for your turn to be provincialized. And obviously, they will make it prospective from the date they give you the provincialization. But then again, that would have invited another cause of action that since you had the benefit since 2013, so you could have claimed that separately.
to consider afresh my petition, my lord, if I get the lease effect from 1/1/2013.
How is that possible in a review petition? If it is allowed. If it is allowed, then of course. If it is not allowed, then matter ends there. So now you tell me what is the scope of review? Error apparent on the face of the record. Despite due diligence, you could not produce that document or whatever before the. Where is that?
Withdrawal of the provincialization order is in violation of the statutory prescription of the service school as well as the constitutional mandate. So, those things, although it was a clear case, in my petition, that has not been considered. So therefore, the error apparent will, transfer.
You could have filed an appeal. There have been a larger scope, you see. In review, we have to detect that error. If it's not detectable, then gone. Why? It was fixed the other day also. Again, today it's fixed.
I think I can satisfy my lord with this application regarding that whether the error.
See, at the first instance, you said that although you were not appearing that day, your name has been shown that you have appeared. It's not believable. I'll tell you why. Because after the order was passed, you could have come straight away saying that, see, I was not there. Why did you put me in? After 3-4 years, you come say that I was not there. Who will believe you? So we'll close your review petition. We have already heard it. We'll dismiss it. What more? See, we cannot go in a full-length hearing. You know very well. I asked you what is the mistake. You have not been able to satisfy me.
Directly saying the honorable court will not what is there.
No, that is a different thing. Even otherwise, you see, even otherwise, what is your other ground for review?
The very purpose for the withdrawal of the provincialization which they have done, the manner in which they have done, that merit assessment has not been done by the report. That's why, there is a error apparent on record and my rights to remain as a provincialized employee from 1/1/2013 has been wiped out. That is the.
Yes, that's what the court has considered it and has disallowed it. Instead, court had said that let them consider you as per the 2017 Act. That also you're not happy about it.
There is no finding, no assumption about that. If the main order is my lord, then it is to tell you.
Who's for the other side? Are you ready? You are ready. Okay, let us peruse your order. Where's the order? Yes. Are you saying that there's no discussion at all on that issue? I just point out, because if you read, it takes a long time.
In respect of the petitioner withdrawn without affording any opportunity of being heard to them.
No, where are you reading from? Yes. Then?
On 14/7/2015, praying for cancellation of the order dated 8/6/2015, aforementioned and to allow them to continue in service, but the same has not yet been attended. Mr. So-and-so learned studies was in elementary education department, Assam for the respondent number 1 to 4, submit that the government sanctioned 2 posts for provincialization of services of teacher working in so-and-so school. But through oversight, the office of the respondent number 2, the Director of Elementary Education Assam issued an order on 14/5/2013 for provincialization of services of 4 teachers of the state school, including the services of the petition. However, having noticed the mistake, the provincialization benefit of the petitioner was withdrawn by an order dated 8/6/2015. However, Mr. Soma further submitted that the respondent number 2 has submitted a proposal to the government for sanctioning of 2 posts against the name of the petitioner. But as this court, by an order dated 23/9/2016, passed in WPC number so and so, strike down the Assam Banser Educational Institution Provincialization of the Services Act of 2011. The government could not sanction the post for provincialization of services of the petitioner, and now the District Elementary Education Officer Walpara has submitted press recommendation of the DLSC under the new Assam Education Provincialization of the Services of Teachers and Reorganization of the Educational Institutions Act 2017, dated 10/5/2018 for provincialization of services of the petitioner. Mr. Sharma therefore submit that the case of the petitioner may be considered along with the other similarly situated candidates whose the provision of the act in due course of the process which is on. Mr. Sharma has produced the letter of the respondent number 2 addressed to whom in this regard which is taken on record. I have given due consideration to the above averments made by the learned counsel for both the sides and perused the records. Perusal of the record revealed that the services of the petitioner were provincialized along with the 2 teachers of so and so schools on 14/5/2015, following the government letter number dated whereby 406 posts of the assistant teachers were created under the provision of the Assam Banser Educational Institution, Provincialization of the Services Act 2011, as amended in 2012. However, the impugned order dated 8/6/2015, the provincialization order of the petitioner was withdrawn by the respondent number 2, the Director of Elementary Education Assam, without affording any opportunity of being heard to them. Thus, benefit of provincialization of the services of the 2 other assistant teachers remain intact, whereas the provincialization of the services of the petitioner was withdrawn without giving opportunity.
Okay, just pause there for a moment. In paragraph 11, the beginning part, the second line, it says provincialization was done on 14/5/2015. This is not 15, I think it's 13. This is a typo mistake. Okay. Yes, you have shown me, page 26. Then paragraph 12.
Whereas the petitioner name has already been recommended by the DLSC for provincialization of the services, the respondents, more particularly the respondent number 2, the Director of Elementary Education of Assam, shall consider the case of the petitioner under the provision of the Assam Education Act of 2017 as expeditiously as possible, preferably within a period of 4 months from the date of receipt of the certified copy of the order, which will be furnished by the petitioner. With the above observation, we have considered the provincialization order, the respected report, has said that 4 teachers were provincialized in the schools, and the only 2 were interfered. Now, the period case. In the previous case, my lord may be pleased to find the repetition where the next. And draw my lord's attention to page 60. Page 60. Paragraph 12, I'm reading. That the fact is that after provincialization of their services, they were regularly getting the salary. That's of the petitioners are the employees within the meaning of section 2A of the Assam Banser Educational Institution Provincialization of the Services Act
And as per section 4 of the said act, they are entitled to the benefit of the Assam Services Discipline and Appeal Code 1964 and Article 311 of the Constitution of India. That the petitioner begs to state that the Assam Services Disciplinary and Appeal Code 1964 provides for procedure and manner in which the penalties against the delinquent officers may be imposed for misconduct of Rule 7 of the said speaks about the nature of penalties, while the Rule 9 laid down the procedure for imposing the such penalty.
Oh, why are you going on that? Why?
Yes. This is the our pleaded case before the respected single before the report below. But the honorable report did not consider all these amendments below and straight away uphold the decision of the because no finding is there. Why?
No, see, what I meant to say was that it's a case of withdrawal of your provincialization. Now you are taking us to a different level, saying that there are provisions under the disciplinary and control appeal rules. Are you trying to say that no such kind of procedures was drawn? No proceeding was drawn against us under that provision, and they could not have taken it. They could not have made the withdrawal just like that.
From that day, there is no provincialization in effect. Once there is no provincialization in effect, the status of the government employee by section 2A has been withdrawn. Once it is withdrawn, the benefit of the government employee is not there. It is an amount to a punishment, without any proceeding, without any opportunity of hearing. These are the pleaded case before the learned report, but these are the things which has not been find place in the judgment. That's why we have came up before my lordships for review of the our petition address.
Yes, what do you say, Mr. Karunir? Yes, page 46.
Case 7, paragraph 6, this is the case of the respondent. Paragraph 6.
Case of the respondent.
Yes, the submits that the government sanctions 2 courses of provincialization of services teachers working in so-and-so lower primary school. But through oversight, the office of the respondent to the Director of Elementary Education Assam issued an order on 14/5/2013 for provincialization of services to 4 teachers, the said school, including the service of the petitioner. However, having noticed the mistake, the provincial benefit of so-and-so was withdrawn by an order dated 8/6/2013.
So what it means that there was only a sanction for 2 posts. Instead, 4 posts have been provincialized. Then why was it not mentioned in the impugn order of withdrawing the provincialization at page 39? You can withdraw, but there must be some reason given, isn't it? Why it was withdrawn?
These 2 posts were sanctioned, and against 2 posts, 4 cannot be provincialized.
Okay, paragraph 6 is based on any affidavit filed by the department, or it's only a submission orally?
Paragraph 9, which was from the letter of the President who addressed to the in this figure, which is taken on record. So the instruction should be the sending council. Which is there were no post measure, their service cannot be provincialized. And if minor allows this repetition also, repetition also, then only that service cannot be granted to the.
No, allowing the writ petition will not, review petition would not mean automatic provincialization. It'll go back to square one. There's a thing. Now, another question which perhaps might have been considered is, when was this review petition filed? The order 2019-20. So, any explanation? Was there any delay, condonation? (7/1/19) is the order. As per the records, the date of filing is 20th of April 2022.
Also.
Hmm.
In one of my case, after 5 years, they have filed a review petition.
Then what had happened to that? That's pending. That will come up. That's why I'm asking you. This is a warm-up. What will happen now? Don't say that we are incorporating the High Court rules and all that and no delay. There's no limitation. What is the position? Any decision? Which decision is that? Arunachal? DB? Whose decision is that? Ansari? DB or single bench? Single bench. I faintly remember there's a DB judgment, but I'm not sure about the citation. Are you aware about that, Mr. Bhuyan? See, otherwise you see, if there's no limitation as such, then what happens? People start digging out their cases after 10, 20 years. They come back and say, review. Then there'll be chaos. Everyone will come with old cases and say review, review. Then what will happen? So in your case also, after 3 years you've come. What is the explanation? Which instruction?
They are provincialized under the 2017 Act, or perhaps there is an access within the order of the.
You're not in touch with your clients. You don't know what has happened. You tell me that. You should have told me that in the first day, the first hour. Are you saying that you want to take instructions now again? Delay part is bound to come up sooner or later. We'll have to satisfy the court. There might already be some judgment which is maybe in your favor also. I don't know. You have to show that to the court. Otherwise, saying that there is no limitation or there's no bar is a dangerous proposition. Because there will be never ending. Cases will be never ending. People will come again. So what do you want to do? Mr. A.R. Bhuyan, Learned Counsel appears for the review petitioner, and Mr. N.J. Khatania, Learned Counsel appears for the respondent. Which department is this? Elementary Education Department. Mr. A.R. Bhuyan, Learned Counsel submits that perhaps pursuant to the order sought to be reviewed, the petitioners might have been considered for provincialization under the, what is the act which is called?
Education,
Yes.
Provincialization of Services of Teachers and Reorganization of Educational Institutions Act.
You got it. Stop further. He submits that he requires some time to make his submission as regards the applicability of Limitation Act in a review petition filed by the review petitioner seeking review of the order passed in a writ petition. Next parent review of above lists this matter again on so and so.
13.8. Thirty of the supplementary list for orders.
This was 28. Where is the explanation now? Let me ask you. Where is your explanation? I have not found your any explanation. Straight away, you have gone to the grounds. So,
They found some defect, which is effect of previous case in our petition.
that will come later on. First, you tell me why you have come after such a long time. This is a judgment or order passed by Justice Vaipe. When was that? 2016-17. See, you're coming after almost 10 years without a single whisper about the delay. Then what can be done? Why should we allow you time? You only know the basic thing that if there's some explanation given without a separate application for limitation, condonation of delay, that can be allowed. But you have not made anything. Heard Mr. N.J. Khatania, learned counsel for the review petitioner, who submits that by filing this review petition, the petitioner seeks review of the order dated 31/3/2016, passed in WPC number 2276 of 2011. Stop. Since this review petition has been filed after a considerable lapse of time, upon being asked as to why it is so, the learned counsel submits that he may be given some time to explain the delay by filing an additional affidavit. Praise aloud. List again after so and so.
On 13.8. 13. For admission, item 21.
Mr. Saikia, what is this matter? Mr. Das Gupta is there on the other side. Private respondent. And any department involved? Sorry? Elementary. You are there?
Yes.
Okay. What is the dispute here? Okay, Mr. Saikia. Mr. Saikia, I'll ask you questions so that we can sort of, settle this issue at the early date. See, there are two schools involved. What is your school? AB school. What is AB school? Higher secondary? Middle school? AB. AB elementary school. Name of the school is AB Elementary. Elementary school. Okay. And the rival school? The other side? Sorry? Betna. Name of the high school? Tell me. Betnath. Where do you get that page number? 35. And the elementary school, where do you get that? Where do you get the name of the elementary school? Page number? Same means Betna. Betna Emily High School. Then your school, what is the name of your school? Where is that? Page 35, which part? Correct, which paragraph?
See the government, please be amalgamated. So that paragraph, madam, name of the school, then name of the amalgamated school.
No, on amalgamation, this is the name. I'm asking you prior to amalgamation, what are the name of the two schools?
That is the name of the school prior to amalgamation.
Which one? Bet.
Name of the high school is Betna Kaurbaha Milon High School.
Yes.
Name of the amalgamated school is Betna Kaurbaha Milon M School. This Betna Kaurbaha Milon M School is amalgamated with the high school file. So after amalgamation, the name is Betna Kaurbaha Milon High School.
So prior to amalgamation also, this is Betna. Hmm?
So because amalgamated with the high school.
Oh. You are middle school. You were ME school, they were high school. Other names are same, except for high school, middle school. Then upon amalgamation, what is the new name? Huh? Oh, please answer the question, Mr. Saikia. See, after amalgamation, what is the name of the school? High school. It will be high school. High school. Your ME school. ME school. Their high school. I think your basic case is that it should have been not high school, but ME school. Okay, you don't want amalgamation. Or there's an interim order. The amalgamation has not given effect to. Your claim is that it should remain as ME school, not as an high school. And the grounds, I think perhaps it's something to do with the number of students. Where is that notification? Where is the notification? Hmm. 27. And which is the relevant clause? Yes, read. So that is your case. When you have more than 100 students, why do you think about amalgamating my school with the high school? So that is your point. Judgment of which, in which case? But the yes. The office memorandum was challenged. Where in page 83?
And certainly, the short and the important stakeholders in this process. Then I think the short or the short with this grievance and unless post the amalgamation would not be in a position to deliver the goods. Full amalgamation, they have to, my lord, issue a notice to us. Are we interested or not? They did not do it. How about civil commission? The number of students I have finished. No.
What does this judgment say? That you have to tell me.
Now, surely, yes, that we have challenged the number now. Good number of customers here. Yeah, in that activity, they are not also. Now, this circular, they have had memorandum, that's memorandum of their ahead. So the memorandum should be, should be part of, high panel. So the memorandum I have read. Under the first, the number of criteria. The number of students are less by law, then it can be amalgamated. Suppose you have only less than 50 students in my class, in our school, then they can amalgamate. If you put a number in India, school can be amalgamated. What? That's the huge number of students are here. Consequently, the number of students I have energy. That is, that's 14 and it's a one. This 14 virtue. This 14. Plus wise, the number of students are in the number will got to be issue. This 16. This 16. This 20. total number of students is more than challenge. And then you got denies. I don't know whether this one is not the honorable bond. Then our I think maybe she will.
Appeal? What do you mean? Which appeal? Hmm? Oh,
Appeal. General public by heart and lover and quality, the public custom is shown in the year 1979. Next school was Provincialized in the year 1985. The school is running very well. There are good number of students, teachers or students in the school compared in the other schools. In a short, the school has not faced any problems. The number of students is most satisfactory.
Lord Master. Lord Jamadar.
The annual result is very satisfactory. The result is last, that often they have what if the amalgamation issue or school is, they have not all got with an high school. You possibly have great objection and resentment, is the amalgamation. The managing procedure of the government or our minutes, without education, minutes, there should be meeting held on 25/90, as presently division number 3, even the amalgamation issue. Therefore, it is most respectfully request you now, not to amalgamate schools who thereby will be justice to general public easy, therefore trust, therefore question. It is our most honest prayer we thanking you. Consequently, the number one is always the president. And the demand of the public. Of public action, family litigation, and that petition was not addressed by the authority. Then also,
So I think what, okay, but what has happened to your representation?
similar already discussed now, right, so High Court, I have from the government.
Which one?
Yes.
WPC? WPC 5261? 61?
So I have given on one.
There's one order here. This is 5261. How it is disposed of? How has it been disposed of? In what manner? Hmm? Reason behind setting aside? Going by the office memorandum. Which order you want to read? Yes, which paragraph you want to read? Hmm.
In instant case, the decision was then, which is expected below. The English school has 4 enrollment, but the year get the students in each class, get the English to make the marks with the year by high school. And the issues are, there are some issues when people of the, not comfortable issue of workshop, in terms of opposition policy. What are the issues of 1983? Well, the issue of decision of 7 national got to be up to the amalgamation. Being by drawing the attention of the opposite cost of the memorandum, effect 22/9/16, historical manufacturing for the commissioner of submitted. Therefore, amalgamate their issue, there has been less than 15 students, number of students in each class, and under the condition the position will be not within the high stakes. But according to the data, negative number of students and staff in this same school, which has been annexed to the attraction to the institution. Historical under terms of qualification and submitted, that should be classes of students, which are more than this increasing number of students, mentioned in class 10. For every reference, the data regarding number of students in various classes is very below. The number of students will be mentioned. We are not what a issue of the coverage. That is that apart from the fact that the number of students in the council school
Mr. Sakya, I have understood it.
But regular of the report. Supposed to have come to one of the process of fiction of something being controverted by respondents. But finally, and therefore, by doctrine of non-divorce, the apartments led by living in to be correct. Even otherwise, this could have looked that the data regarding students not justify other of the issue in the school with the inclusion in the high school. The policy should publish this. The area of Islam will become nearby high school does not appear to be applicable in this case. Good on the issue of number of students and the distance factor. Distance factor and also about question of distance topics. School was issue was that part and interim order first one. You of the above, school of the opinion, that the interim order so far. But the interest in order, publication of start from some is liable to interpret which is already done. Considering the part of the interim order is deception. Number one, how much good of there and the issue? The private respondent was
Private respondent. Okay. Page number?
Order. That petition was rejected. Private respondent filed a petition for maintaining the order that there was another hearing on the report under the petition.
Okay.
They have right to issue your report.
Private respondent is respondent 11. You're 11.
Yes.
Respondent 11.
You are not, you have to come to application or data after.
Oh, I see.
There are tests. Definitely, they don't have any.
The high court, government.
Hmm.
What from that the high school they will come because their result is very bad. Even if it has been worse, students have in the high school. The result is hopeless. And our result was not higher connected by petition. We have got scholarships, good number of scholarships. All these students after passing the issue go to the high school, where their result is not good at all.
Only for that reason.
That is why they are trying. That let us bring them to us. Let us teach the.
Your school has a good name. So they want to share your good name. What is wrong in that? Yes.
Yes, 98. 98 days. The implemented method particular management, the boss on the basis of all the content of all these, you can send the boss that will not be high school. The order of accessory in the application number so and so. These are the order, the orders, these are the orders. Selling the mother memoranda, that means the mother office memoranda. They are concerned that no individual school can, but the office memoranda was silenced. And that was dismissed, but has given me my observation I have read that the students, the school should be first addressed. Yeah, a big person should not be left alone. That is because the cases that myself have conducted in the same that when the High Court held that let the memorandum, let the process of memorandum be complied with by the government. But they did not comply in this particular cases. And in good number of cases, my lord, I have been conducting cases and got us another order, madam, set aside. Not only this two, and they have concerned they are trying to distribute our court, my learned friend, my respect. That these cases have been dismissed. What are these cases? These are the cases that I have read with my petition that I have annexed in my petition. But that been my lord here. That all these common cases. That was common doctor. In same place.
I think you have already read out that judgment. Yes, yes.
Memoranda, not amalgamation. The two chapters here. One is amalgamation, other one is circular. When the circular was kept again, the authorities bound to follow the circular. They themselves are violated the circular. And this statements made by my learned paid, not paid. My lord is trying to mislead the order of court. I have gone through judiciary. Now, lordship, I have read that page 83. That even if the authority wanted to amalgamate, the first address the agree person. They never asked, are you interested? Are you willing to be amalgamated? This paragraph 28, they themselves have violated it. Page 83. Now, the purpose of this circular was that if the number of students are less and both schools are in the same campus, then that can be amalgamated. But if the number of students are more than 15, it can be amalgamated also. They are silent on this paragraph. I have read the objection at page 88, another application submitted by this petitioner and the general public. Page 88. The application that is submitted one to the inspector, another to the block elimination officer. Page 88. Petition is not only in a submission. This should be appeal.
This has not been considered? Okay.
They will share that in your office memorandum, organ with remedies there, there is appeal. You have appeal.
Appeal. Under what provision? Where?
That's why we have the last line was there, everyone request substitute. Direct of concern, Procedural topic.
Yes.
Direct of concern with issue necessary order for amalgamation. For any institution, or whatever the institution, public may either acting before the government in secondary or elementary education department, as we can study, or elementary. So this another application was submitted. The elementary block education official. Respect of shop. You can give respect. You have to stay.
It's okay, you don't have to read it. I think you're. So this is the only provisions for appeal, isn't it? The OM provides as such. If you are aggrieved, public may prefer appeal before the government. And you have preferred 2-3 appeals. Nothing happened, that's why you come before the court. So question now is whether to amalgamate or not. You say that as per the OM, it says that if you have a student which is less than 10, then it may be amalgamated to the nearest school. Since you have more than 100 students, there's no question of amalgamation. And what do they say in the counter affidavit? They have not filed. But there are some affidavits here. 11 has filed. 11 has filed. Then who else has filed? Who else has filed? Oh, one is the reply. So government department, you're not filing an affidavit. When did you file? Which respondent? Number 4. Respondent number 4. Who's respondent number 4? Who is respondent number 4? Hmm. No, why the government doesn't file? I've seen that. See, the government doesn't file. Normally it's the director and all that all the time who files it. Shouldn't the government file? It's their policy of the government. Director is not the government. Hmm? That's what you say. What I'm saying is that director is not the government. It's a policy of the government. Hmm.
OM is very clear.
Then why did you violate your own OM then? If it is very clear, then how do you say that?
27.
If it's less than 10 students,
Mention about less than 10.
then what are we reading all this time? 15 students.
It's 28.
No, come to clause 10. What is this then?
Clause 10, if any school has 4 enrollment that is less than 15 students in each class, then the any school may be merged with the nearby high school. May be merged with the nearby high school. The word is nearby. Here,
Before that, the students has to be less than 15
exactly.
in all the classes. Now, what is the strength of the students? They say it's more than 100 enrollment.
It's not the high school, which is the same campus, not the nearby high school. Because here clause 10 refers to a nearby high school. But in the present case, while you can come to page 28 by
So,
clause 1.
which clause is applicable
Clause 1 is applicable.
according to you?
Clause 1 is applicable in
What does it say? Please read.
all the schools situated in the same campus shall be merged with the highest school. That is, if there is a higher secondary school in a campus, then other high school or ME school or LP school or all of these schools situated in the same campus, all other schools shall be amalgamated with higher secondary school. Likewise, if the highest school is high school, then all other schools subordinate to the high school shall be amalgamated with the high school.
Okay, where is the definition?
Order.
No, before that, where is the definition of campus? How big is the campus? How big it will be? All schools situated in the same campus shall be merged. Supposing they say that we are not in the campus.
recording of.
35. Is this the impugn order? Is this the impugn order?
See there, the government of Assam is pleased to amalgamate the common school with Betna, Kaurbaha, Milon High School under the section scheme for amalgamations which are located on same campus.
Hmm.
You are clear finding on it's
All right.
same campus.
Okay.
But in case of the enrollment is less than 15, in that case, my lord, school will be maybe merged with the nearby high school.
Hmm.
But in case of same campus, shall be amalgamated with the higher school.
As per clause 1.
Yes, sir.
So I wanted to know what do you mean by campus?
One campus. Within one campus. Within the same.
Campus. There are no other buildings or private houses or anything. It's within one compound. No, you have your own building. They have their own building, but if it's a one campus, then you have to be merged. That's what the clause 1 says. What is the idea behind? What is the idea behind merging all these schools?
In fact, my lord will find in the scheme.
You have not. That's why I'm telling you, the government should have filed an affidavit. They are the one who have framed the policy.
The scheme, first paragraph. First paragraph, page 27. The department is receiving various proposals for amalgamation of different categories of schools located in the same campus, which are still pending due to absence of clear policy in this regard. It has been found that there are many common campuses where different categories of school, higher secondary, high school, ME school, and even the LP school also exist in the same campus. In spite of location of these institutions in same campus or in a nearby place, these schools are run individually with separate classroom and other individual academic programs. In such cases, the service of teachers of one school are not shared for the students of another school even in need. As a result, the shortage of teachers of one school is not addressed by the teachers of the other school. On the other hand, in private sector, these schools are mostly composite school having classes right from LKG, KC to 12 standards, which facilitate economy in administrative with optimum utilization of services of employees and also provides the platform of linkage of education. Moreover, on single circle provincialization schools under the ambit of Assam Social Act, some schools having very few enrollments have been taken over. These schools having low enrollment require merger with another schools, which may also facilitate savings of administrative costs. So this is the objective of amalgamation. The schools within the same campus. Yes. In fact, my lord will find the.
So, what is the concept of this campus? Anything else to be said? In all the districts, various districts, there are schools of various grades, all operating in one place, but having separate building.
But in separate building.
So, for administrative convenience and to have a composite school, and so that even the teachers can be shared, it should be merged together to one school. That is what it means. See, you're going to clause 1, he is going to clause 10. So, so what do you say about the other judgments have been relied upon by the learned senior counsel? Is it a case of similar nature?
In fact, petitioner is
And we are also.
Petitioner has filed this writ petition, my lord, because of clause 6, my lord. Clause 6.
Clause 6.
The reason for filing this writ petition. Clause 6. So petitioner demonstrated that clause 10 is violated, but actually he is agreed by clause 6, my lord. In the event of highest school in high school, the headmaster of the high school shall continue after amalgamation. The post of headmaster of any school shall be designated as assistant headmaster with same pay scale whatever they are drawing, and the post shall be held by the existing headmaster of any school without requiring the qualification for the post of assistant headmaster. So petitioner is the headmaster of any school. After amalgamation, he will be the assistant headmaster. My lord, can we come to page 36? 36. Page number 12. Headmaster, petitioner Roman. He is a petitioner. Last column, my lord, A is same, is assistant headmaster. So after amalgamation, he will be the assistant headmaster. That is why he filed it. That is the only reason. No other reason. This is the only reason.
We have challenged, we have good number of students. And that is why it's all.
That is why we want to share the.
Doesn't pass by the High Court, have never been challenged by the authority.
That is the only reason he approached this honorable court. Nothing else.
No, that's the High Court. Right. The reply to the director, this particular was issued by the government of Assam, Municipal Secretary, but it is not kind review. By the commission of that page,
But Mr. Saikia, you have not addressed regarding clause 1. You are diverting us to clause 10, which may not be relevant after all. Are you denying that you are not in the same campus? Whether it may be a big campus, it may be very, very big campus, but it's a campus. No, that may not be the thing. See, if it's a campus in as per clause 1, idea behind is that instead of having small units here and there, better have a larger unit.
Should be given. In our school, already authority.
Okay, can we settle this matter in some other way? That the respondents give him a personal hearing and take a call. Because this will go on and on. We don't know. You see, what are the facts? We don't know. No, number of students, that perhaps there's no argument on that. But when it comes to campus, that's another thing altogether.
Before the amalgamation, the school students and public should be addressed by the authority.
Exactly, that's what I'm saying. They'll give you a personal hearing why school should be amalgamated.
And state level. Here is the director himself should be ordered. Receiving any letter from the district state level committee, what you can see. And Mother, it is the interest of all concerned. Getting allowing all the stockholders in this process. And certainly, teachers are an important stockholders in this process. And unhappy teacher, all the teachers in this regard, unaddressed post-amalgamation could not be in a position to deliver the goods. So, we have such a situation, a given situation mechanism, let it put in place. Let upon response, use response of the concerned issues may be called for. And consider before final decision taken on amendment and further. So this department has been passed long back. And it is in force. And they are violating the law. They did not address us, did not hear us.
So now they will hear you.
Yes, but.
You have any problem on that? They'll give you a hearing. You give your submission satisfactorily up to your satisfaction before the authority, because this order has been issued by the government. And no, it's by the government. I don't think so. Please come to page 35. Commissioner and Secretary to the Government of Assam is the government, on behalf of the government. Yes, please see that properly. Please see properly, page 36. That's a different thing.
Number. Was suspended long back. Because for professional case, the petition was rejected. That order is there. The petition for getting in the same submission was there. Here, the litigation can pass. Regarding number one clause also made same submission. But that was not accepted by the court. Now the number, if they issue us the notice of direct us to submit.
Mr. Saikia, see, you can go on arguing like that. There's no point. I'm telling you, we'll dispose it off by directing the authorities to give you a patient hearing on the amalgamation. You give your objections, whatever, and within the time frame, they'll decide. Until then, that amalgamation will not happen. That protection will be there. I think end of the day, that will be the order. Because the government also has not given their affidavit, but since the order has been passed by the government, and you claim that you have not been given a personal hearing, referring to a judgment of passed in earlier, and OM stands as on today. What is the difference? Don't pass it on like that. So which will be applicable? And this amalgamation happened under 2019. I'm sorry, OM of 2016, but the amalgamation happened in 2019.
There are some committee also, block level committee, district level committee, to replace that because.
Precisely, that's why you ought to have filed all those things by way of an affidavit. These things are not known to us, na? And that will prolong everything. You have no, but see, is there anything which is to his disadvantage in the 2021? Anything which will go against him for the other side under the new OM?
Conditions are slightly different.
That's why it will not be fair, na? 2019, something happened. That part is okay. I've already indicated, but you have come up with 2021 OM. You are saying that it should be disposed of as 2021 OM. Will it have any? Mr. Saikia? Why not? Why not?
I have not seen this type of they did not file any affidavit, so they will go on.
Mr. Khatonier, we are in 2025. Suddenly bring out an OM as if it is filed, taken out yesterday. It's 2021. You ought to have filed it earlier. What is to be done?
And if they want 5 years, it's continuing. And nothing wrong happened with them also.
Okay, so we'll adjourn it. I thought we could dispose it of. Huh?
We can on and reply.
Please write down, heard Mr. R.C. Saikia, learned senior counsel, assisted by Miss K. Saikia for the petitioner. Stop also heard Mr. N.J. Khatania, learned standing counsel, School Education Department. Mr.
This memorandum was huge in the year 2016. That was challenged before this court. And this court upheld this operational order.
It's okay.
That order, the High Court, they went to the Supreme Court. Supreme Court also upheld this one. So case is in a narrow compass. Whether these ME school and the high school are in the same compass or not. If it is same compass, then it must be amalgamated.
Okay, anyway, let them file affidavit. Mr. A. Das Gupta, learned senior counsel, assisted by Mr. J. U. Ahmed for the respondent number 11. You are there? BTC. BTC, this is in the BTC area or what? And Mr. B. Chaudhary, learned standing counsel, BTC for respondent numbers. Oh, yeah, SSA. Standing counsel, BTC and SSA for respondent numbers. 7, 8, and 9. Okay, no SSA, BTC only. Respondent number 7, 8, and 9. Next para, grievance expressed by the petitioner is that the Secondary Education Department has unilaterally amalgamated the Betna Karubha Milan High School, Baksa, with Betna Karuba Milan ME School. Without taking the petitioner school into confidence and in violation of office memorandum dated 22/9/2016, more particularly clause 3 within bracket 10 of the said OM. Stop. During the course of the argument, it has come to light that the office memorandum dated 22/9/2016 has been superseded by office memorandum dated 3rd August 2021 in respect of the government's policy on amalgamation of schools. First off, it is seen that apart from the Director of School Education, the state government has not filed an affidavit. No, you write like this. Apart from the Director of School Education and the respondent number 11, the state government has not filed an affidavit against the writ petition. Stop further. By virtue of interim order dated 10/1/2020, the amalgamation order has not been given effect to till date. Stop. Under the circumstance, for a proper appreciation of the case, the respondent, the secretary to the government of Assam Secondary Education Elementary Education Assam, the bracket respondent number 3 shall file an affidavit in opposition incorporating the new office memorandum of 2021 and also explaining the policy, the aim and object behind framing such a policy for amalgamation. Let such affidavit be filed on or before 3 weeks should do, on or before 16th of July. List the matter again on so and so subsequent date.
18/7.
Yes, 18/7. Yes, you were saying, Mr. Saiki. Okay, you add this also. At some part, Mr. R.C. Saiki, Lanet Senior Counsel. In support of the case of the petitioner has relied upon the following cases. Number 1, WPC number 1, order dated 2/6/2023, passed in WPC number 5261 of 2018. Please open the bracket. The President School Management Committee of Barkhopa ME School and another versus State of Assam and 9 others. And number 2, order dated 2/6/2023, passed in WPC number 5258 of 2018. Open bracket. President School Managing, the President, School Managing Committee of Bolajhar and another versus State of Assam and 9 others. Stop the Learned Senior Counsel submits that no appeal has been filed against the said judgments. The said decision of the coordinate bench of this court. All right. You file it. I think there's no requirement. It says without leave of court, they'll not happen. Huh? No. I understand, Mr. Saikia. See, there's already an order which says that there'll be no amalgamation without leave of this court. So that takes care till disposal. All right. Not required. Okay. Let it be like that. Yes. We fixed a date already.
18/7. He wants it in the month of August.
Yes, tell me when do you want it? Okay.
Many matters,
Hmm?
31 many matters.
Many matters. Oh. 1st August.
22 to 25.
Today we are out of time. What to do? We are out of time. Tomorrow there'll be difficulty because court may rise early tomorrow. We have that reference coming up, perhaps. And, I'll give you a date just after the vacation. Court master, any date? Where's Mr. Gogoi?
21/7,
21/7. What is that date?
Monday.
There are 10 cases. There are already 10 cases there. 10 matters already on 22.
Problem is somebody that can point to rights.
You can take your chance, perhaps. There are many cases. Mr. Gogoi, today is not possible. So we have it after the vacation in July. Come to a consensus for which date?
Astrid will be not here, even I will be there from 53rd onwards. Very card.
Of July. Okay, let's have it on 24th, Thursday. As agreed to by the parties, this is the matter on 24th of July for admission hearing. 24th.
26.
This also date has to be given. Mr. Bhuya, this also will have to. August? First week August.
Yes, sir.
As paid for by the parties, list the matter.
On 7th.
On 7th of August. Interim order passed earlier shall continue till that date. Parties are also at liberty to exchange further pleadings.
27.
We'll have to adjourn it today, not possible. Give a date, I think conveniently.
First week of July, August.
You are for? Okay, as paid for by the parties, list the matter on
8th.
8th of August. The Higher Education Department shall file their affidavit.
Because the college is not cooperating with us since 2023. I am submitting on record.
No, don't submit all that. Honor before 1st of August. Honor before 1st of August. Your affidavit.
They are saying that we don't cooperate. I don't know how.
This is the record, not my submission. I'm submitting on the Mr.
I didn't take the responsibility by filing affidavit.
What's in progress, coming still, the provider the reference of the. We have already, we were waiting to 23. Till now, they have not provided.
You incorporate that in what you have to file. We'll see. Yeah, give him a copy, give the senior counsel. There's one more matter left, I think.
Yes, for hearing item 29.
Mr. Boya. Who's for the other side? Okay. Okay, as paid for by the parties, list the matter
19.
for hearing on 19.8. Anything left?